Hello, everybody. Hello, Nana Laura. Hello, C-Rex. Please get some sweet sleep tonight. I'm going to miss you. Oh, thank you. That's very necessary. Ava says so. Don't you, Ava girl? Come on up. Come on. Hello, Chinny. Hello, Charlie. How you doing? Hope everybody's having a great night. Look at Ava. She hopes everybody's having a great night too. Actually, she's just here for the treats. You want some beef liver? You want some beef liver, girl? Oh, pretty girl Ava. Get a couple of these out for her. Hello, Spider-Man. Here you go, baby. Whoop! I dropped it. You'll have to go find that one. It's at my feet. You can get it. You can get it. There you go. I nudged it. I nudged it to her. So tonight, we're gonna have some fun. We're gonna start out in Thurston County. We got some Kansas. And some Michigan. And it came. I literally watched court all day today, trying to find cases, and it was a rough one. So at the very end of what I do have is Judge Gettler's docket, I think from yesterday. So I really love him, bow tie judge. I don't know if what he did was any good, but I do know I enjoy watching him. So, the end will be a surprise. Hello, my Costco one. Hello. Welcome. I'm so happy to have you here. Oh, I'm getting nudges. She wants lovin's. You want lovin's, baby girl? You want lovin's? Look at ear flops. That's our best. That's our best. Aw, sweet girl Ava. So that toy that was sent by C-Rex, oh my goodness, they love it so much. It's like it goes off every 2 hours for 10 minutes and they go crazy. Ava, move. I'm going to push the button. Give me just 1 second, okay? Give me just a second here. I'm going to push the button. I've got it set on top of the dresser. And there she goes. There she goes. Earl earlier was literally hanging from the flag. It was hilarious to watch. So, so that'll give you guys some entertainment while the cases are going. Oh, it'll be fun. It'll be fun. Yeah. It's Ava's favorite thing. Ava loves the laser toys. And so she gets just as much enjoyment out of this as the kitty cats do. Earl just goes psycho for it. It's great. I love it. I could not have asked for a better toy. The only thing is I can't leave it in here overnight. Because if I leave it in here overnight, I'm going to get trampled on in my sleep. So, yeah, because the kitties, they don't sleep at night. They chase the laser, and they chase the laser on me. Hey, Earl, how you doing there, buds? Yes, I know it's going, baby girl. Oh, honey. We're all riffraff around here. It's kind of the theme. Look at what you did, C-Rex. Look at what you did. They're all so happy. Thank you so much. Oh my goodness. Like the little sparkles. I could see that. I could see that. Look at Earl. Oh my gosh. I know. I really should. I really should. Like a 24-hour stream. Just putting her head on the bed. Oh my gosh. Yeah, 24-hour stream of the PAWFURM. All of their shenanigans at play. I don't know. I'd have to give them their own room because y'all, I promise you, you do not want a camera in my bedroom. Hello, Chris Roach. Oh. Oh yeah, so that's what's going to be going on for about 10 minutes. I feel like I'm in the way. Oh my gosh, we need Billy's fat butt in here. I think he's still outside, actually. He wanted to go outside earlier. I need to go check. I need to go see if Billy needs to come inside. All right, hold up. Let me find tonight's cases. Because he's a little stinker. He gets out and he doesn't want to come back in because he's gotta roll around on the driveway and make sure it sufficiently smells like him. So yeah. But it's nice out, so it's not like he's, it's not like he's gonna freeze or anything. It's beautiful outside.
And sir, what's your name?
Dan Taylor.
Sorry, that Taylor, was it?
Dan Taylor, yes.
Okay, Stan Taylor. All right, and so you're Stanley D. Taylor?
Yes, I am.
What's your date of birth?
12759.
Okay, so I'm gonna turn to Mr. Sabian. You worked with Mr. Taylor?
Yes, Your Honor. Two cases. One over the charges with Mr. Taylor would like to enter a plea of not guilty as to both waive a formal reading of the rights and stipulate to the probable cause statement.
Okay, so that's on 5A183518, the allegation of use of drug paraphernalia from March 22nd. You
Yes, Your
pled
Honor.
guilty to the November 2024 possession of controlled substance already.
Sorry about that. Yes, Your Honor.
Okay, clear. So Mr. Taylor, you're charged now with an allegation of March 22nd, 2025 of use of drug paraphernalia, and we hope to see you on April 3rd, and you weren't there, so a warrant was issued, and here you are today. And so I'm going to hear from the lawyers, the prosecuting attorney, and Mr. Sabian on your behalf about release conditions. And I'm going to appoint counsel. Let me see. Was there previous appointment, Mr. McClellan with?
He the last case resolved. It looks like Pacific Point Defense was appointed on that prior matter.
Okay. All right, so we'll appoint Pacific Point Defense again to represent you, one of the lawyers there. So I'm going to turn first to the city prosecutor, Mr. McClellan.
Your Honor, the city is asking the court for the booking bail on both. It's $1,000 each case. Looking back, I think that case ending in 8050, the post-conviction matter, he failed to appear at that arraignment, was held, and then did resolve that case, and then failed to appear at this arraignment. So there's been warrants issued each time that he's been served notice out of custody. So and then this is city making that oral motion revoke on that backup matter. So the request would be $1,000 cash or bond, no possession of a controlled substance without valid prescription, and no law violations. On the backup matter, just comply with any conditions of that sentence.
And Mr. Sabian?
He is riding that struggle bus all the way home.
Yes, Your Honor, we're hoping the court will consider not imposing any time or giving Mr. Taylor the credit for time served. It was a bit hard for me to communicate with him. I think he's still maybe struggling with issues. He's currently not employed and is retired. I don't know how doing time in jail, I don't know if that's going to change his life drastically or deter him, because I believe he still has a chemical dependency. We're hoping the court will consider nominal sanctions or no sanctions at all, and letting him appear on the new case in the near future on a PRT. Thank you.
And Mr. Taylor, do you have a place to call home in Rainier still? Mr. Taylor? Can't hear you.
Yeah, somewhere I do.
Okay, so I've got this address on 118th Avenue. Is that good for you? Is that something that you get mail at, or is there a PO box out there?
Yes, it's a mailbox.
Okay, so is that, do you know your address for mailing?
Mhm.
Mr. McClellan, when did Mr. Taylor be brought in Nisqually? What time? Was it today? Was it yesterday?
It was. Shows I'd have, yes, it was the 7th of April. I don't know the time exactly.
Okay, so sometime yesterday.
Yeah.
So Mr. Taylor doesn't look.
I can't believe, I mean, I don't know how long people stay like on that stuff. Like, I don't know how long it takes for the effects to wear off. I've never done it, clearly. Because an entire day and still being this affected, that seems like a lot. That seems like a heavy dose.
Look like he's doing very well today.
Yeah.
Mr. Taylor, how do you feel? Do you feel well or unhealthy or what? Mr. Taylor? I'm not even sure if he's on the nod. So I don't think he's competent for today's hearing. I'm going to set to tomorrow directly to 1:30 for a pre-FTC and arraignment, and hope that he is more cogent then. Just hold him until tomorrow. We've already found probable cause in the underlying matter when we issued the warrant.
Yeah, I think that makes sense, Your Honor. Thank you.
Thank you, Your Honor.
Mr. Taylor, I think you need to knock on the door there and they'll let you out of the room. Mr. McClellan, maybe you can be into, he's moving.
Yeah,
Let's see.
I'm shocked he could just get up and walk out like that. He was literally bent over in the, you know, when you see those people on the streets like bent over at the waist, just what is that called? The fentanyl bend or something like that. He was completely crashed over. And she said, just go knock on the door. And he's like, okay. Gets up and walks away. Like, wow. I don't know. I don't know if he is. But that's messed up. Yeah, for sure. For sure. Oh, honey. I've been so worried about you lately. I actually was gonna message you and ask you how it went with my sweet Scott sis. Did you get to meet Nicola? I wanted to hear about that, and I wanted pictures, and I got neither. I'm really sorry to hear you're not doing well. I love you so much.
So it's
and then having to go resolve those issues down there. I don't think this is one where probation is necessarily required, especially when we know other counties are going to be watching him while he resolves his other cases.
This is an update. Do you remember the guy from the other night who went to the ER and demanded they do open heart surgery on him? Yeah, this is him. And it's kind of an update to his case. And I'm going to quick run Ava out.
I would ask the court to give him that opportunity to have this just be time served with minimum fines and costs. And if it helps, I do waive my attorney fees so the court is aware.
Mr. Hartel or Mr. Carnes?
Thank you, Your Honor. Defendant was previously arrested on March 4th for disturbing a peace incident, and now, and I do recall him saying during that sentencing, his plans pretty much exactly the same as what he has said today. And then we have this incident on March 29th. I do take this seriously. I'd ask the court to impose a sentence of 93 days jail. Thank you.
You only pled to a 90-day.
Nine, excuse me. My apologies. 90.
Mr. Spencer, is there anything you'd like me to know?
I told you everything that happened.
Well, Mr. Spencer, I want to thank you for your demeanor today. You were in a lot better mood today than you were when I arraigned you, and you were yelling at me and flipping me off. So I appreciate that.
I'm sorry. I lost it. Like I said, I have mental issues, and when they took me off all my meds that I've been on 30 years, I have to deal with it. And I've just got done doing 22 days in jail.
Did you work with CMH while you were in the jail?
Yeah, the whole time. And I'm supposed to go to a mental hospital in Hurley. I asked them to go to the hospital in Flint. They haven't taken me. They said you might have to go here, but they haven't done nothing for me yet. I want to go to the hospital to get back on my meds and stay there until because I need to be locked up until I'm on my meds, you know. And they're not giving me the meds that I'm on now. They're giving me different meds. That's not. I've been on these meds 30 years. I was molested as a little boy. I need to be on what I need to be on. I don't know what to got.
Were you on your medication when you had the last incident at the hospital?
For 2 months because I haven't had no source.
Last time we were here, you had indicated that you were going to go down to Kalamazoo and take care of your issues down there.
I was only out 2 days. I need this heart to put on because I'm going to die. I got AIDS though. That's what I was trying to do. Both times they arrested me.
And then you'd also indicated, I thought you were going to go to Florida.
There's a rehab in Florida. The city police are going to send me to. They're the ones that sent me up here to stay safe because I got robbed in Kalamazoo and then I got shot at. They said you got to get out of town and you're not going to be able to testify. Well, them people finally took a plea bargain and gave up the other two. So she said, how would you like me to go to Florida to rehab? I said, I'd love to. I'm trying to, but every time the city cops do, they arrest me. Because my daughter's the one that took the head of the militia out, her share. My daughters are both sergeants in Berry County. My daughter's been there 23 years. She could have retired. She stayed 3 more years because her sheriff is the head of the militia. So she stayed 3 years, took him out. Now every time the city cops see me, they arrest me. I've been arrested 5 times. I got arrested the day after I got here in Traverse. I've been arrested 3 times in Traverse because it's all by city cops. because they know that I'm the father of Rochelle Spencer. That's why I'm getting arrested by the city cop. County's never touched me. I haven't done nothing wrong. But the city cops keep arresting me. And that's the honest truth. You can check with Berry County. You can go down and call them. She's been there 23 years. She was a canine for 19 years. She was SWAT for a year. Now she stayed 3 more years. And now every time they see me, they're taking me to jail. Anytime they have contact with me, I'm going to jail.
You mentioned Hurley. Did you have an intake done down there?
They called them. I don't know. The jail called them and asked if they had a bed for it. I don't know. They don't talk to me. Jail isn't. They're, I don't know why. I asked to go to the mental hospital. I said, even here, if I can't go to Hurley, send me to one hospital till I can get back on my right mind. But they want me to stay in jail for the money, I guess. I don't know why they're doing it. That sounds true. I don't have any idea why they won't. I should have already been to the hospital. I asked a week and a half ago to go to the mental hospital. Or a week ago when I came in. I guess 9 days, 10 days.
Your Honor, if we could fashion a sentence with immediate release to mental health treatment, I do believe our office social worker Brian Henniger could help with some of the steps.
Do you know, has your social worker had any contact with mental health regarding him?
He has. I'm not sure if they visited my client at the jail, but okay, I'm being told yes, but I do know Mr. Henniger has reached out to me mental health.
This is what I'm going to do, Mr. Carnes.
Your Honor, I am requesting that we delay sentencing a week and see if I will work with CMH, see if they can come up with a plan. Because I would much rather do that than a 90-day jail sentence.
Well, and that's what I was just going to recommend. I'm going to adjourn sentencing today. Mr. Hartel, if you can have your office reach out to CMH, find out what's been going on, if anything, and then also see if your social worker can get a plan put together for him. Because I don't think he needs to be locked up, but last time I released him, we're right back here. So I don't want to set him up for failure. So we will set this over till next Wednesday. And if everything gets put together before that, I have no objection to moving it ahead if we need to, but anything else?
No, Your Honor, thank you.
Okay.
So for the Colby Schlottman matter, do we have all 3 defendants or just, okay, so let's go ahead and call in. All right, Mr. Schlottman, if you could please unmute your microphone. Thank you.
Of course. Hello.
Hello, Ms. Cruz, please unmute. Mr. Rosa. Okay, so we're here in matter 25S000053. We have the plaintiff Colby Schlottman present. We have 2 of the defendants, Leticia Cruz and Galilea Uroza. Ruperto Lopez Delgato, may I ask where he is? Is he a significant other of someone?
I'm over with my mom, Your Honor.
Oh, so you're there. Is that your name, Ruperto Lopez Delgato?
I'm her son. My father isn't here. I asked the office I called yesterday and I asked if my dad would have to be present, and they just told me that it wouldn't matter if my dad was present or not due to his work he has. And
No, that's fine. I'm sorry. I'm just trying to understand. So you're her son. The individual speaking, hey, sir, are you her son? Yeah, who are you? Are you her son?
Edwin Lopez Cruz.
I'm just asking, are you her son?
I'm Leticia's son.
Yes, Leticia is your mom, correct?
Yeah, I'm her son.
Okay. All right, thank you. All right, so Ruperto Lopez Delgato is your husband, right, ma'am? Leticia, okay, perfect. Yeah, he doesn't need to be present if he's your husband. That's okay. I just wanted to make sure. All right, so today we're here just purely for procedure stuff to make sure all the right papers have been filed. So I'm going to go look at the proof of service. Ashley Schlottman. All right, so we have sufficient service, so we do have proof of service. I'm gonna go ahead and look at the small claim form. All right, so Ms. Cruz and Ms. Rosa, are you aware that Colby Schlottman is asking for $2,090 from you?
Yes.
Okay. Ms. Cruz, do you understand what I'm saying, or do we need a translator in the future?
She would like to consider in
I'm sorry, I can't hear you clearly. Are you saying she needs a translator in the future?
yes, yes, Your Honor. She would like a translator in the future.
Okay, for today, are you able to just tell her dates, sir?
Yes,
Okay.
yes, Your Honor.
For when if we go to trial, I will make sure there's a translator present, okay?
Thank you, Your Honor.
Can you confirm, is it a Spanish translator that's required?
Yes, Your Honor, a Spanish translator.
Thank you. Thank you. So, all right, so both parties are aware that $2,090 is requested. At this point, would the parties like to go to trial over this amount, or can an agreement be reached?
Diciendo que está platicando que si tú estás, si entiendes que lo que está.
If an agreement is reached, how would that work?
So if,
Like, would it? Oh, yes.
oh,
Would
no,
it be
so
through
it's,
us or would it be through the court?
Get ready for this to get messy.
so if it was through the court, I could sign a judgment right now saying that you owe him $2,090 and you would work with Mr. Schlottman to work out a payment plan or find a way to reimburse him that money, but that would be between you and him.
Mhm.
If you want to do something outside of the court, then you would just work with Mr. Schlottman to figure out how to reimburse him without me having to sign any paperwork. But that is up to the
Okay.
parties.
And yes, and if it were to go to trial, how would that process work?
Well, if it goes to trial, Mr. Schlottman would present his information that he has as to why he thinks he should get $2,090 back. And then you would present your side as to why you don't think you owe him that money or you owe him a different amount of money. I would be the
Oh,
judge who
okay,
presided over trial.
Oh, I understand. Also there's one thing. I like this case to be directly towards me. The only reason Leticia is here is for receiving the payment because we didn't have time to put input my information or build the Venmo account, but I can provide all of that now. I have a bank account and a Venmo account I can use. I don't
I'm
see
sorry,
why
I'm
Roberto is
confused.
included.
Can you state that again? It's sort of hard to hear you. You said that you don't know why Leticia Cruz is here?
No, I understand she's there for receiving the payment, but does she have to stay for the case or can it be directly towards me since I'm the responsible one and the one who sold him the vehicle?
Well, that's up to Mr. Schlottman. Why, Mr. Schlottman, have you included someone that wasn't a party to this matter?
The only reason why, Your Honor, is because both Roberto and Leticia are the ones that the registered owners of the car, and Roberto is, from what is the signing person on who sold me the car. Missy Russo was the only person responding as far as the Facebook ad, which is why I added her on here, but I just didn't know. It was highly confusing as to who out of the three, was supposed to be the one it was directed to, because it was
Well, it's you're suing for buying a truck that was not advertised correctly for its
correct.
issues. So, I mean, essentially you would be suing the individual who's selling it, so the registered owner of it. So in that situation, it'd be Leticia Cruz and Ruperto Lopez, correct?
Correct. Yeah, they're the ones on the lease. I mean, on the title.
All right, and Ms. Rosa, how are you part of this?
I was the one who posted it on Facebook and sold it. I never got the title changed because I never really had the time to, so that's why they're probably there. But could it be directed towards me since I am the responsible one for this?
So you're saying that, so who is Miss Cruz to you?
A family member.
Did you buy the car from them and then you never transfer title within 45 days?
Yeah, yeah, that's what happened, and
And
I
then
never transferred it to my name, but
And by doing so or not doing so, you've now entangled her in this lawsuit, and she's still a responsible party. If he chooses to go ahead with it, it would be joint and several liability.
I did buy it from her.
Okay, and then you sold a car without having transferred it?
Yeah, I honestly don't know much about cars, so I understand how it's a mistake. But I would just like to be the one fully responsible for the case.
Mr. Schlotman, what's your response to that?
I would, if anything, I wouldn't mind like Leticia, not being a part of it, but Roberto's the one who signed it, and she's the one who posted the ad. So I would like those two to at least be the ones in there.
How was Ruperto involved, Miss Urosa, if you bought the car from them?
Well, since my cousin did help out getting the vehicle towards Colby, I think he told because that's his father. He told his father to sign to be able to give him the title, or because that's what he signed for, right? To be able to give him or just sign that he did sell the car towards him, since I wasn't on the paperwork yet.
All right, Mr. Schlotman, I think that that's valid. I think that in this situation, because Ruperto is still on the title, even though Mr. Rosa was the owner of the vehicle at that time, she didn't transfer. I think that it might be redundant to have Leticia and Ruperto on both as defendants in this matter. If you just want to simplify, and we could drop it to just Ruperto Lopez and Galileo Rosa, if you are comfortable with that.
Yes, Your Honor.
Okay, so at this point, we're just going to amend the defendants to be Galileo Rosa and Ruperto Lopez. Would Ruperto Lopez need a translator?
Yeah, he would.
Okay, Spanish as well?
Yes.
Yeah.
Yeah.
Okay, so Miss Leticia Cruz, you do not have to be here for the next trial, but Ruperto Lopez will have to.
Okay, and another question my mom had, Your Honor, was when was the next court date going to be, so I can inform my father of the next.
I'm setting that right now. I'm
Thank
setting it right now.
you,
So on May 21st at 2:30 p.m. Does that work for Ruperto and Galilea?
Yes.
Does that work for you, Mr. Schlotman?
Yes, Your Honor.
Okay. All right.
Can I verify that again? It's May 21st at 2 p.m., Your Honor.
2:30 p.m.
2:30. Okay. Thank you, Your Honor. That works perfect too.
Okay, so I'm gonna go ahead and write the trial in 25S 1, 2, 3, 4, 5, 3. So on May 21st at 2:30 p.m., trial will be here in virtual courtroom 8. I will be the judge presiding over the trial. All parties need to have video footage. So Galileo Rosa, I need to be able to see your face during trial, okay?
Okay, that's fine.
Thank you. So that day we'll have video feed of everyone. How it's going to work, since I set trial for May 21st, let me give everyone dates. So that means May 9th, that's a Friday. All parties need to drop off any evidence or exhibits that they wish to use in their case. All of these exhibits, there needs to be 2 copies of each exhibit. That's because one will come to me as a judge. The other one will go to the other party so that they can see what the party is bringing against them. Then on May 12th, which is Monday, all parties can come to the district court clerk's window and pick up the exhibits that have been dropped off for them. The reason why drop off is Friday the 9th and pick up is the 12th is because I'm not setting a specific time for drop off on the 9th. So that way no one will be coming in asking for exhibits that haven't been dropped off yet, okay? Does that make sense to everyone?
Yes, Your Honor.
Okay. I want to clarify, all exhibits needed to be dropped off by May 9th. I've had a lot of people dropping exhibits off post that. Any exhibits dropped off post the 9th will not be accepted for trial. So please make sure you have all your bills, documentation, communication screenshots, everything brought in, please, so that I have it with me on the 9th.
May I ask a question, Your Honor?
Yes, sir.
As far as what you mentioned earlier in regards to the like coming into an agreement, I didn't know if that was anything they were up to. I didn't know if we had that part and then we're past it. If we did, I didn't hear
So
anything on it.
it seemed like we were proceeding on to trial. However, this doesn't ban you guys from speaking to one another. If you are amenable to speaking to the other parties, it seems like Miss Urosa is who you should be speaking to. If you have her contact information or a way to reach her via social media or however, if you guys can maybe talk and come to an agreement prior to the trial date, that would be great, because honestly, anything that hits trial isn't necessarily the best. So hopefully
Yeah.
it can be resolved before then. And this doesn't ban you from speaking to one another to try to resolve it.
Of course,
Okay,
I
and
would
if
I
we
was.
were to be, oh, sorry.
You're
Go
fine.
ahead, Miss.
Sorry, you would go.
Okay, Mr. Rosa, go ahead.
If we were to come to an agreement and do like a payment type of plan, how would we have to put the court in or let you
No.
know or sign
No.
some paper? No? Okay.
Yes. So I would not need to know anything about your payment plan. However, Mr. Schlottman, if you do come to an agreement, you do need to file correspondence with the court saying we have reached an agreement. So that way I can file a dismissal of this case. So that way it's not clogging our system waiting for trial, because there has been a resolution already. So that's the only thing that would need to happen. I don't need to know anything about the monetary payment plans or anything. That's none of my business unless it gets to trial.
Would you'd mentioned the two ways, us doing it personally and then us doing it through the court.
Mm-hmm.
I would prefer to do it if we did come to an agreement through the court. How would I go about doing that?
Well, then you would have to wait until trial, and
Okay.
then on the day of trial, I could enter a judgment if everyone's in agreement. The only issue, sir, and I think a lot of people don't understand this, is when we get to trial and I enter a judgment, it's just a piece of paper that essentially says that someone owes you something. The court is in no way involved in actually obtaining that money for you.
Of course.
Okay. Because I think a lot of people are like, great, will the court now assist in getting this money? Nope.
No,
No.
of course. It would just legalize the matter that it would be owed.
Yes,
Yeah.
there would be means to recoup the money if you didn't get it afterwards. But
Okay.
if you do not reach an agreement before trial date, we could just enter a judgment that day. Okay.
It's wise to have it solidified in the court documents. It's kind of like having an officer come to the scene of the accident to write a report for the insurance company. You just can't trust people's word anymore.
All right. Thank you, Judge.
All right. Thank you, guys. See you then on the 21st, unless something is figured out before then. Okay.
Of course. Thank you, Your Honor.
All right. Bye.
Okay, thank you.
Holland or Brooks? My waiting room went away, but I will. Here we go. All right, Mr. Holland, if you could please unmute.
I did.
Ms.
Yes, ma'am.
Lauren, Miss Lauren, if you could please unmute.
Done.
Thank you. All right,
you
so
guys
we're
want
here in
over here?
cause 25S000054. I have plaintiff Peter Holland here. Raynell Brooks,
Yes,
is
she's
that
right here.
you? All right, plaintiff Raynell Brooks is present as well. We have the defendant Larry Lauren, present. Larry. Okay.
Larry Lauren. Probably Larry Lauren. Yeah.
All right, so let me go ahead and look at, to make sure that procedurally we are set. I do have proof of service filed. I want to make sure that everything is correct on there. All right, so I do find that there is sufficient proof of service. We're going to go to the small claim form. So I see that Holland and Brooks, the plaintiffs, are requesting $1,599.93. Are you aware of this, Miss Lauren?
Yes, I am. What I can say is, while I got served, I didn't get served a document along with the small claims thing. So I only got the paper saying what they're suing, what the amount that they're suing me for.
That's all that you should have received.
Okay, I just wanted to make sure. It says that there should have been a document of proof, and I didn't get that.
The document of proof would have been what the court received. That's nothing that you need to get. So you, as long as you receive the small claims form that has 2 pages, that's the amount they're seeking, then that's all you have for now.
Okay.
All right. So based on that information, would you like me to go ahead and enter a judgment for that amount, and then you could pay Holland and Brooks, or would you like to go ahead and set a trial date?
I'm actually fighting it because the phone isn't
Okay.
worth that much. I gave them
Okay.
back the other property. And I paid off over $600 of the phone. The phone was mine that I was paying off. And then we got into a fight. They wanted me off. AT&T told me I could trade in the phone. I did
Okay,
that.
I'm sorry. I can't hear to, I'm can't listen to the actual evidence, but let's go ahead and set a trial date if you don't mind.
Yeah.
My
She just admitted right there that she traded in the phone.
Okay, we'll hear about it then on May 28th.
That was $1,600
at
phone.
1:30 p.m. Does that work for both parties?
I'm sorry. I'm sorry. What was the date again?
May 28th is
May
the soonest at 1:30 p.m. Does that work for both parties?
Yeah.
Yes.
I can do that.
Okay, so I'm going to go ahead and write that in 25S000054. So that means with trial on the 28th at 1:30 p.m., it will be here in virtual courtroom 8. So you will sign in the exact same way. Both parties must have video footage. So Miss Lauren, you need to have something where I can see your face on that day. All right.
Okay, that's fine. I'm sick today. That's why my face
That's fine. Because trial's on the 28th, that means on Friday, May 16th, you must drop off all exhibits or evidence that you wish to use against the other party at the district court clerk's window. Once again, that's May 16th. Please provide 2 copies of every document because I will retain a copy and then one of those copies will go to the other party so they know what's being presented against them. And then on the 19th, which is a Monday, all parties can come pick up the evidence and the exhibits. And that's the reason why there are 2 dates is because I'm not setting a deadline for it to be dropped off on Friday. So that way I don't want someone coming here and the exhibits haven't been dropped off yet by the other party. If you're here on Monday, they'll for sure be here waiting for you if there are other exhibits then.
So we could drop it off on Friday, the 16th, like 8:30 or so, 8:39.
No, I'm not setting I'm not setting a deadline. Drop it off whenever you want on Friday, May 16th. Pick it up on Monday, May 19th.
Yes.
Trials on the 28th at 1:30 p.m.
Okay, we got all that. Yes, ma'am.
Okay.
Thank you.
All right. Well, then I will see you then on the 28th.
Okay, thank you. Thank you.
Thank you.
Yeah, and what a lot of people don't realize, now obviously the case hasn't happened yet, but I can kind of see where it's going to go because the amount that you get for a trade-in value, her saying the phone's not worth that, well, you're not going to get what it's worth from the trade-in value. And when you get a phone, you're getting it at a much lower cost than it retails for because you're signing a contract or you're agreeing to commit to payments over time. So that phone probably does retail for $1,600. And you may have made some payments toward it, but when that contract cancels, when they kick you off that plan, they have to pay the remaining of the full amount that's still due. So yeah, she might not be on the hook for the full $1,600, but whatever the retail value of that phone is, she's going to be on the hook for, because she traded it in. She could have given it back to them, and then they could have continued to use it on that line or on another line of theirs, but she didn't do that. So I kind of want to see that one, because I think she's screwed.
Polycom. It's there we go. All right. Bring in this.
Uh-oh. I think what you're witnessing here is my fabulous editing skills at play. I think I accidentally left in this dead spot, and I'm sorry.
Here's here. Here's attorney Zayed. I don't see Zayed. Laura, we got everybody here. AP, I got the whole prosecutor's office. Miss McHale, Miss Schultz, Miss Washington. All right, well, good afternoon, everyone.
Hi, Judge.
I have the entire prosecutor's office here.
Hi, Judge.
Hey, this is a conference, I guess, with Judge Bowie. You have Mr. Dwyer, Miss McHale.
Yes, Judge. Is there an
Mr.
ETA on
Vitale.
him? I'm just juggling Judge Matthews here, so I'm in the hallway.
Okay, they got him at 2 o'clock. So if you want to come back by then, that's
Okay.
yeah.
Okay, I'll just mute myself and just wait to see him on the screen.
Okay. No worries. I have Mr. Sallin here. He has Johnson, who's a jailer. Ellen Michaels has England. Okay, let's bring in England. And Burns will be on at 1:45, Ms. Schultz.
Okay, I'll just stay on, Judge.
Okay. All right. Ms. Kamaj, we have Ellen Michaels and Miss England.
Okay.
All right, Ms. Michaels, are you ready?
I am, thank you.
All right, give me 1 second. Are you ready, Ms. Neal? Ready, Ms. Neal? All right. This is 250332FY. People State of Michigan versus Rochelle Marie England. She's charged with count 1, controlled substance possession of controlled heroin or another narcotic less than 25 grams, and count, I believe it should say count 2. It says count 3 on here, but operating license suspended, revoked, or denied. Appearance to the record.
Good afternoon, Your Honor. Laura Kamaj on behalf of the people.
Good afternoon, Ellen Michaels, P67943 on behalf of Rochelle England. We agree to proceed over Zoom.
Ms. England, good afternoon. Please state your name for the record.
Rochelle Marie England.
Okay, we're here for probable cause. How are we proceeding?
I'm asking to adjourn the probable cause. I just received a good phone number for my client. I reached out to her. We haven't had a chance to talk. So if we could go 2 weeks, please.
Okay, Miss England, please raise your right hand for me. Do you swear or affirm, subject to the pains and penalties of perjury, testimony you give this court be the truth, the whole truth, and nothing but the truth?
I do.
You may put your right hand down. You do have a right to have your exam on your felony charge within 21 days of the day you are arraigned on this case. Do you understand?
Yes.
So you were arraigned March 28th. That means your exam has to occur on and before the 18th of April. Well, actually the 17th of April, because the 18th is Good Friday. Do you understand that?
I do. Can you repeat that charges though?
The charge,
I do
count one,
apologize.
which you were arraigned on, was controlled substance, possession of narcotics less than 25 grams. That's the charge. You were arraigned on it. But back to my questioning. Are you okay with us scheduling your exam after the 17th of April? We're not waiving it. We just want to schedule it outside of the 21 days. Are you okay with that?
Yes.
All right. I find that Miss England's waiver is 21 days. Ms. Michaels, the 22nd does work. That'll be at 1:30 on Zoom.
She seems genuinely shocked by the charges. And she'd be the only one.
Thank you. Miss England, could you please call me when we log off?
Yeah, what is the phone number?
248-202-3345.
All right. Thank you.
Thank you so much.
All right, Bob, we'll continue. You're all
Thank you
set.
so much. Have a great day.
You too. Thank you. Yes. Okay. Okay, I got Mr. McNeil. I'm bringing him in off Arkira Jones. Mr. McNeil, good afternoon.
Good afternoon, Your Honor.
All right, I have Mr. Jones here. We're ready to go on the record with his matter. This is 250191FY, People State of Michigan versus Fakir Sharad Jones. He's charged in count 1, weapons, carrying concealed, count 2, weapons, firearms, possession by a prohibited person.
I'm sorry, Your Honor. I don't think you pronounced his name correctly. It is not spelled as Fakir. It looks a little bit different if we're going phonetically.
Count 3, operating with license suspended, revoked, denied. Second offense notice, appearance to the record.
Good afternoon, Your Honor. Laura Kamash on behalf of the people.
Good afternoon, Your Honor. Brandon McNeil, P number 81300, appearing on behalf of Mr. Jones, who is present on Zoom.
Mr. Jones, good afternoon. Please state your name for the record.
Dr. Jones.
Okay. We are here for probable cause conference. How are we proceeding?
Your Honor, I have had the opportunity to receive discovery. At this time, we would waive the preliminary exam.
Okay. Mr. Jones, please raise your right hand. Do you swear or affirm, subject to the pains and penalties of perjury, testimony you give this court be the truth, the whole truth, and nothing but the truth?
I do.
You may put your right hand down. You do have a right to a preliminary examination in this matter. Do you understand?
Yes.
I will examine the complaint and witnesses in support of the prosecution under oath in my presence. Do you understand?
Yes.
At this exam, prosecution must prove probable cause these crimes committed in the city of Pontiac, and you are the individual that committed them. Do you understand?
Yes.
All right, and at the conclusion of the exam, at the exam, you have the right to testify, subpoena witnesses, offer evidence, and have your attorney examine and cross-examine all witnesses. Do you understand?
Yes.
All right. And if I find at the conclusion of the exam probable cause has not been established, these crimes were committed in Pontiac and you were the individual that committed them, I can reduce them or dismiss the case. Do you understand?
Yes.
The felonies, I can reduce or dismiss the felonies, but by waiving the exam, you'll be bound over as charged in Sixth Circuit Court to potentially stand trial. Do you understand?
Yes.
Your bond and your bond conditions remain the same until amended or modified by a Sixth Circuit Court judge. Do you understand?
Yes.
So after speaking with your attorney, Mr. McNeil, and thinking about what you want to do, is it your informed decision to unconditionally waive your exam and be bound over?
Yes.
Waiver of this exam is not subject to appeal or reversal at a later date. Do you understand?
Yes.
Anyone promise you anything, threatening you or forcing you to waive the exam?
No.
And you're waiving the exam knowingly, intelligently, and voluntarily. You do understand the consequences of what you're doing?
Yes.
All right, Ms. Kamaj, on behalf of the people of the state of Michigan,
People waive, Judge.
I find Mr. Jones has waived his exam knowingly, intelligently, and voluntarily. He understood the consequences of doing so. Does not disclose anyone on this record threatening him, promising him, or forcing him to waive his right to have his exam. Therefore, Mr. Jones, you're bound over Sixth Circuit Court as charged. Your arraignment date to be 10 to 14 days from today. The Circuit Court will let you know, and your bond is continued. Mr. McNeil, I need a waiver form. Ms. Camacho, in my court, I get waivers. They got to sign off on the waiver. So we'll Ms. Neal will put an email to both of you of that form. I need it back.
Will
Thank
do,
you,
Judge. Thank you.
All right, thank you. You're all set.
Thank you.
All right. Mr. Phillips, we have Tynesha Clemens here. I'm just gonna change her name, sir. This is 250-388-FY, people of the state of Michigan versus Tynesha Denise Clemens. She is charged with count 1, felonious assault with a dangerous weapon. Appearance of the record.
Good afternoon, Your Honor. Laura Kamaj on behalf of the people.
Good afternoon, Your Honor. May it please the court, Kerry Phillips appearing on behalf of Miss Tanisha Clemens, and we have no objection to proceeding this afternoon via Zoom.
Ms. Clemens, good afternoon. Please state your name for the record.
Good afternoon, Tynesha Clemens.
Okay, we're here for probable cause. How are we proceeding?
Judge, I had an opportunity to speak to my client and discuss this matter. She has indicated to me that she would like to hold a preliminary examination.
Okay. Ms. Clemens, please raise your right hand. I'm sorry. Do you swear or affirm subject to the pains and penalties of perjury testimony you give this court would be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your right hand down. So you were arraigned on March 27th on this felony charge. You do have a right to have your exam within that date, within 21 days. Do you understand that?
Yes.
So you were arraigned March 27th. This means your exam has to occur on or before the 17th of April. Do you understand that?
Yes.
Are you okay with scheduling your exam after the 17th? We're not waiving it. We just want to schedule you to have your exam after April 17th outside of the 21 days. Are you okay with that?
Yes.
All right, I find Ms. Clemens' waiver 21 days. Mr. Phillips, we are booked and busy this spring. I can do the 25th. I'm sorry, that's a Friday. My apologies. That's a Friday. I can do the 29th at 11 or 2 of this month.
Is that April or May?
This month, April.
April. Yeah, I'm scheduled for a trial on the 29th. We have no problem, Judge, going into May.
I can do May 1st at 11. I can do May 6th at 11 or 2.
How about May the 6th at 2 o'clock?
Okay. All right, that'll work. That'll be in person, Ms. Clemens, here at the 50th District Court for your exam, okay?
Yes, sir.
All right, we will continue your bond. If there's nothing else, that will conclude this matter.
Thank you, Judge. Ms. Clemens, I'll be talking to you, ma'am.
Thank you.
All right. All right, Mr. Milton, you're here. I thought I brought in your attorney, Mr. Rayner. Mr. Rayner, good afternoon.
Good afternoon, Judge.
All right, we're ready for your case. Let me call it. 250315 FY, People of State of Michigan versus Akinyele Milton. He's charged with count 1, weapons carrying concealed, count 2, weapons, firearms, possession by prohibited person, count 3, felony firearm, count 4, police officer assaulting, resisting, obstructing, and then count 5, weapons, felony firearm. Appearance for the record.
Good afternoon, Your Honor. Laura Kamash on behalf of the people.
Alan Reiner appearing on behalf of defendant, who I don't see on the screen.
He's on the screen. He's on the screen. State your name for the record, sir.
Akinyele Kiara Milton.
What? Okay, go ahead, Mr. Rayner. You don't have to have your hand up, sir.
Okay, I'm sorry.
You're fine.
Excuse me, Judge. Everything's fine.
All right, we're here for a probable cause. How are we proceeding?
Judge, I've had an opportunity to discuss this case at length with my client, and I was able to see all of the discovery. That would be the police incident reports and a portion of the video. And then I discussed all of that with my client, and without belaboring this, I'm going to ask the court to consider allowing my client to have a forensic exam. I'm concerned about criminal responsibility. I believe that he's competent. That's not an issue, but I believe there's an issue in criminal responsibility.
So criminal responsibility is something that we can order down here, but they're not going to have it unless it's at circuit court.
My understanding, Your Honor,
then-
is that it's done at circuit court as well.
Yeah, we can order it just to have it in, hopefully get it on the books. But as far as it being done, they won't provide a report here at district court. It will have to be at circuit court.
Well, in that case, if what would you suggest, Judge, that we ask for it and not get it and then move on, or?
So, I mean, you're not asking for a comp exam, so you're believing he's competent to stand trial.
Absolutely.
Or to move forward to an exam. So, I mean, that component, is relevant to this jurisdiction. So, I mean, based upon that,
I see.
I don't know how you want to
Then
deal with that.
in that regard, Judge, excuse me, I'm sorry. In that regard, my client would waive his right to a preliminary exam today. He understands that the prosecutor's obligation or burden is, he understands that. He understands too that the prosecutor only need to prove reasonable belief that these things happened, that he committed the crime. Knowing all of that, he's prepared to waive his right to a preliminary exam.
In that regard, that's pretty much just the lawyer trying to buy time to figure out what the heck to do.
And have the case sent to the circuit court.
Mr. Milton, please unmute yourself and raise your right hand. I'm sorry, do it again. Unmute. Do you swear or affirm, subject to the pains and penalties of perjury, testimony you give this court be the truth, the whole truth, and nothing but truth?
Yes, sir.
You may put your right hand down. So you do have a right to have a preliminary examination in this matter. Do you understand?
Yes, sir.
All right, that I will examine the complaint and witnesses as part of the prosecution under oath in my presence. Do you understand?
Yes.
And at this exam, the prosecution must prove probable cause that these crimes were committed in the city of Pontiac and you were the individual that committed these crimes. Do you understand?
Yes, sir.
All right. And at this exam, you have the right to testify, subpoena witnesses, offer evidence, and have your attorney examine or cross-examine all witnesses. Do you understand?
Yes, sir.
This man has not been in trouble since he was 7 years old and reached into the cookie jar.
And if I find at the conclusion of the exam that probable cause was not established that these crimes were committed in the city of Pontiac, you were the individual that committed them, I can dismiss or reduce the charges. Do you understand?
Yes, sir.
But by waiving the exam, you'll be bound over as charged in Sixth Circuit Court to potentially stand trial. Do you understand?
Yes.
All right. And your bond conditions remain the same until amended or modified by Sixth Circuit Court judge. Do you understand?
Yes, sir.
So after speaking to your attorney, Mr. Rayner, and think about what you want to do, is it your informed decision to unconditionally waive this exam and be bound over to Sixth Circuit Court?
Yes, sir.
All right. Waiver of this exam is not subject to appeal or reversal at a later date. Do you understand that?
Yes, sir.
Is anyone promising you anything, threatening you, or forcing you to waive this exam?
No.
And you're waiving this exam knowingly, intelligently, and voluntarily. You understand the consequences of what you're doing?
Yes, sir.
All right. Ms. Kamaj, on behalf of the people of the state of Michigan.
People waive, Judge.
Thank you,
All right.
Judge.
I find that Mr. Milton has waived his exam knowingly, intelligently, and voluntarily. He understood the consequences of doing so and has not disclosed anyone on the record threatening him, promising, or forcing him to waive his right to have his exam. So you're bound over as charged at Sixth Circuit Court, Mr. Milton. Your bond will continue, and your arraignment date will be 10 to 14 days from today, but Circuit Court will let you know. Mr. Rayner, Ms. Neal probably already sent you a waiver form. Mr. Milton's signature need to be on it, your signature, and Ms. Kamaj. So you're all set, and I need that back.
Thank you, Judge.
All right, thank you. You're all set,
Thank you,
Mr. Milton.
Thank you.
Mhm.
Hello.
And now we get to watch Judge Gettler. Like I said, this is bonus court. This is surprise court. This is completely unedited, other than I took out the time gaps. But I love Bowtie Judge. He's one of my favorites.
Good morning.
Good morning, Your Honor.
All right, we are resuming the criminal docket for April the 8th. And we are
Yes, sir.
calling State of Kansas versus Jesus Rodriguez, case number MGI 25CR86. Mr. Rodriguez, we called your case a little bit ago. You had not joined the room and a bench warrant was issued for your arrest. I did get a note, however, that says that you had logged into the wrong Zoom session. Is that right?
Yes, sir. I'm sorry about. Yes, Your Honor. I'm sorry about that.
All right. Well, I'm glad you made it. You avoided yourself getting arrested for failure to appear in court. Now, we did appoint, you're on for a attorney review today, and we did appoint Jack Villamaria to represent you. However, that was a very recent appointment, and so I don't think he got sufficient notification of that, and so he was not present today. But you do now have an attorney. His name is Jack Villamaria. Do you have a pen and paper? I can give you his telephone number.
I don't, Your Honor. I have one inside. Can I go inside real quick?
Or I'll tell you what, if you want to just contact the clerk's office, or do you report on supervision with Mr. Driscoll?
Okay.
Either one of those. You can either contact Mr. Driscoll's office or contact the clerk's office where you got the Zoom information, and they can provide you with your attorney's telephone number.
Oh, okay. Perfect, Your Honor.
That way, when you have a pen and paper handy, you can do that. We're going to put this on my May 6th docket at 9 o'clock by Zoom. Now, that will be a different Zoom link than the one you used today. So if on May 6th you sign into today's Zoom session, you're going to have the same problem you had today. It'll be the wrong one. So you want to be sure to contact the clerk's office before May 6th to get the current Zoom meeting ID and password.
Okay, perfect, Your Honor.
Okay. Do you have any questions for the court?
No, so May 6th.
May
at
6th.
9 a.m.
You got it.
Okay, I got a question, Your Honor.
Okay, go ahead.
I received a letter at home talking about some administrative dismissings. I don't really know what that letter is about.
A letter about what?
About some in the note it was telling. Oh, I received my license back in that paper, and in that paper it was talking about some administrative dismissed.
All right, you're referring to an administrative hearing, which is something that this court doesn't handle. That's a separate proceeding before
Okay,
a different judge at a different location. So you have to get information on that from somebody else.
Oh, okay, perfect, Your Honor. All righty.
Ms. Plash, could you have anything up on the record on behalf of the state?
No, Your Honor.
All right, we'll see you May 6th at 9 o'clock by Zoom. Be sure to give Mr. Driscoll a call or the clerk's office, and they can give you your attorney's telephone number.
All righty, Your Honor. Thank you very much.
All right, you're free to go. Thank you.
All right.
All right. We still do not have with us Mr. Vaughn. I admitted him to the room again after removing him to the waiting room so we can do our care and treatments. And when I readmitted him, he left the room. Those are case numbers MGI 21 CR 447 and 25 CR 26.
Your Honor, I show at the last hearing that he also had tech issues, but was able to appear later. You ordered he complete a financial affidavit, report for fingerprinting and processing, and report to bond supervision by 4 p.m. I'm unaware if he's completed any of those tasks.
Mr. Driscoll, are you aware whether he made supervision?
I was actually going to request that the court remind him to report weekly. He's kind of been reporting every other week, hit and miss on bond supervision.
All right. Well, I'm going to order a bench warrant for Mr. Vaughn. It would not necessarily be the court's intention to hold him indefinitely, but long enough to essentially advise him that he needs to start reporting for court in person. It's apparent that Zoom is not going to work out for him for whatever reason. So I'm going to suspend his bond until he can be picked up, appear before a judge, and given a court date with instructions to appear in person.
Thank you, Judge.
All right, we will proceed then to informal first appearances. Deputy, whom do you have available?
Jessica Barrow.
Jessica Barlow, okay.
Jessica Barrow.
This is State of Kansas versus Jessica Barlow, MGI 23 CR 194. Ms. Barlow appears in custody by Zoom, having been arrested on an arrest warrant issued by Judge Reynolds, alleging probation violations. Ms. Barlow, there was filed an information, or a statement rather, by your intensive supervision officer, Jessica Cota, that alleges you violated your probation in 3 respects. The first is that you failed to report to your ISO as directed, allegedly failing to report on March 11th, 2025. And then on March, hang on one second, Barlow. And then on March 12th, Ms. Barlow, hang on one second. At this hearing, I'm not getting your response to these allegations. I'm simply advising you of what the allegations are. You'll have a later date to present your response or defense to the allegations. And I would remind you, the state has to prove these. This is just what's being alleged, okay? You may have a very valid defense or explanation for each of these allegations, but I have to advise you of what they are. So the first is you failed to report as directed, specifically allegedly failing to report for supervision on March 11, that on March 12, you allegedly failed to inform your ISO that you had contact with law enforcement. And then on March 18, your supervision was transferred back to the 14th Judicial District from the 11th District. And on April 3rd, you failed to inform your ISO of previous law enforcement contact. The second set of allegations is that you failed to refrain from violating the law. Specifically, it's alleged that on January 25th, 2025, you were arrested by the Kansas Highway Patrol for DUI, for interference with law enforcement, for criminal damage to property, for failure to give proper signal, for improper turn, for improper driving on lane roadway, and for failure to wear seatbelt, that resulting in Labette County case number LBP 25 CR 66. And then on March 11, you were arrested by the Parsons Police Department for interference with law enforcement, their case number 25-0233. And also in that same case, arrested for battery on law enforcement officer. The third allegation is that you failed to avoid injurious and vicious habits. Specifically, the allegation is that on March 11, you were identified as intoxicated in the arrest report from the Parsons Police Department. So those are the allegations. Do you intend on hiring an attorney to represent you in this case, or do you want the court to consider appointing an attorney?
I'd consider appointing one, sir.
All right, the deputy's going to give you an application and an affidavit for court-appointed counsel. If you'd be so kind as to fill that paperwork out, return it there to the jail. Upon receipt and review by a judge, if you qualify financially, we'll appoint an attorney to represent you. This is a Judge Reynolds case. So your next court date will be next week, Tuesday of next week, as a matter of fact. So that's going to be April the 15th. And as far as bond is concerned, I show that when your case was pending originally, your bond was $10,000 cash or professional surety. Ms. Plash, could you have a bond recommendation for this PV matter?
State does not see any failures to appear on that bond, but would request that the defendant be held before so that Judge Reynolds can review bond with her.
Your Honor, I currently have a U-Haul in my driveway. I am currently moving from Parsons back to Cherryville, and it's a mess. I mean, I would request that you would consider giving me a bond for the next week. I know I have court next week, but it's just a mess at home. And my PO knew that, like I was trying to get moved so that I can go into inpatient rehab. And it's just, I have a lot of stuff and I have a U-Haul in my driveway. Like,
all right, Ms. Barlow, I will set a bond of $10,000 cash professional surety. You need to report to your probation officer should you make that bond. I'm going to have you report in person at 1:30 on Tuesday, April 15 in Independence. So if you're not in jail, be sure to turn here to the Judicial Center, second floor, large courtroom by 1:30. And that will be for attorney review before Judge Reynolds. If you fail to appear on that date, assuming you're not already in custody or still in custody, there'll be a bench warrant for your arrest. Any questions about that?
no, sir. Thank you.
Anything further from the state, Ms. Plashka?
No, Your Honor.
All right, thank you.
Ethan Bryant. Ethan Bryant, Your Honor.
Thank you. State of Kansas versus Ethan Bryant, MGI 23 CR 118. Mr. Bryant appears in custody by Zoom. Are you his attorney of record, Mr. Rickman?
Yes, I am.
All right, with Mr. Rickman, stayed by Ms. Plashka. Mr. Bryant, you are appearing having been arrested on an arrest warrant alleging violations of a diversion. There's a motion to revoke diversion on file. It is alleged that you failed to report as directed, that you failed to report to Community Corrections after December 20th, 2023. You did report on that date, but did not report thereafter. That a contact letter was mailed to the last known address for you on North 20th Place in Independence on April 24th, 2024. And then on May 7, 2024, a contact letter was mailed to you but returned by the U.S. Post Office as undeliverable, as you were not residing at that address. The second allegation is that you failed to pay costs associated with the diversion, that a diversion fee of $300, no payment's been received, that there was a diversion monitor fee of $200 with a remaining balance of $120 with no payments since December 2023, and that court costs of $238 were ordered with the remaining balance of $148 with no payment since December 2023. As a result of those allegations, the state is seeking to revoke your diversion. Again, those are the allegations which the state would have to prove, but that is what they are.
Your Honor.
Hang on one second. I'm going to have your attorney speak on your behalf.
Okay, thank you. Judge, I'd like to set, this is Judge Reynolds' case. If we could set this for next Tuesday afternoon at 1:30 for a court review hearing, and I'll go over and see Mr. Bryant and figure out how we're going to go forward. As far as bond, I'd ask for $568 cash. That's what he still owes, with a surety bond of $2,500.
Ms. Plaschko?
Sounds reasonable to the state.
That's kind of crafty. I gotta give him that. At first I heard the number 568 and I'm like, what? That's such an odd number. But yeah, making the bond the amount of what he still owes the court. I like it. I like it.
It does sound reasonable. I don't know whether I have the authority constitutionally to order a cash-only bond. So I hesitate to do that, even if it's by agreement. That's been an issue that's raised in the past, and I try to avoid issuing cash-only bonds.
I understand, since there's no conviction, Your Honor. I understand your concern.
But I will set a bond of cash surety, and that will be $2,500 cash or professional surety. So, Mr. Bryant, you either need to post $2,500 to the clerk of the court, or you can go through a bondsman. If you do that, you would pay them no less than 10%. Your next court date is going to be April 15th. That's Tuesday of next week. There'll be a 1:30 in person. So you'll need to report in person at 1:30 if you make that bond. If you're still in jail, they'll just bring you up in the afternoon when they're ready for your case.
I just had a couple minutes on it.
Hang on, your audio is all jumbled. I know it's not your fault, but I can't hear you at the moment. I think there's a bad connection in the jail.
Ethan, I'll go see you this afternoon in jail. Okay.
Right. That's all for today. Thank you, Mr. Bryant.
I was about to say, I just wanted to make a comment. I didn't ever get read my Miranda rights. And also, I was living with my mom at the month of May, whenever you said the contact letter was
Well,
sent.
hang on, Mr. Bryant, couple of things regarding the contact letter and you residing with your mother. I mean, you may have defense to those allegations, and you can present those to Judge Reynolds at a later date. And Mr. Rickman can give you an education on Miranda warnings and when those have to be given to you. All right, thank you.
Okay,
That's all for today, Mr. Bryant. We're finished this morning. Thank you.
Thank you. I'm going to log out.
Right, thank you, Mr. Rickman.
Robert, Your Honor.
Thank you. This is State of Kansas versus, well, actually it's just Madeline Trauber. It's a new PC from the Sheriff's Office. Their case number MGSO 25-363. Ms. Trauber, you appear in custody by Zoom, having been arrested for attempted violation of protection order, violation of conditions of pretrial orders, for a very similar offense for something that I appeared you on a couple weeks ago for the same thing. And that is an allegation that you sent a letter attempting to have contact with an individual that is part of your no contact order with this criminal case. So that's the allegation. I do show that in the case in which that condition was set, 24 CR 417, that you recently entered a plea in that case, and that matter is set for sentencing on May 27 at 9 o'clock before Judge Collins. Ms. Plaschko, the last time Ms. Trauber was arrested for a very similar offense, that is sending a letter to somebody else with instruction to contact a victim, the state declined to prosecute the case. Do you know if your office is going to decline to prosecute this one as well?
I do not, Your Honor. Ms. Johnson handles all of those decisions.
All right. So I'm going to set this for hearing next Tuesday, Ms. Trauber, April 15th at 9 o'clock by Zoom, and that will be determined whether the state is going to file charges for attempted violation of protection order.
I would absolutely be shocked if they fail to prosecute twice. Like the first time, giving her a break, okay, whatever. But she did it again. All right. And I don't think that's okay. If they let her go on a second violation of attempting to contact someone from her no contact order and attempting to contact a victim in the case? Heck no. No, 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 no. They need to come down on her for that, or she's just gonna keep doing it. Hi, Billy.
So you'll appear by Zoom. You'll appear by Zoom on April 15th at 9 o'clock to see if charges have been filed.
Your Honor.
Okay.
The state would request an admonishment of what the no contact order actually means for this defendant.
I think we went over that with her before. She should be aware of it, but I'll do it again. And Ms. Trauber, the allegation here is that you sent a letter to Jake Trauber with instructions for him to tell your child how much you love and miss him. You're to have no contact of any kind, direct or indirect, with any victim or witness. You're not to pass messages along to your husband, whoever Jake is to you, to pass messages along to your child. No contact of any kind. That means from you directly or from you asking others to pass messages along on your behalf. Any questions about that?
Okay.
All right.
I'm sorry, I just thought I meant direct contact.
So I would just caution you about writing letters in general, as you're gonna, it seems, to yourself in further trouble. You entered a plea to a very serious offense, which you're gonna be sentenced at the end of May. And I'd hate for you to complicate your case even further by violating conditions of your bond.
Yes, sir.
All right, so you will see Judge Reynolds next Tuesday, April 15th, to see if the state is going to file charges as a result of this alleged violation of the law. They declined to the first time. I don't know if you'll get lucky this time, but you'll find that out next Tuesday.
Yes, sir.
All right, thank you.
Thank you.
I think that concludes the docket for this morning, unless I missed something, Ms. Plaschko.
I am reviewing really fast, Your Honor. I don't believe so, except for, no, we finished Mr. Vaughn up.
Yep. Okay, I'll see you this afternoon.
Thank you.
Thank you.
Yeah, I really want to find that previous hearing. I'm so curious if I have it. Hold up. That would be, where would I put that? Okay, hold up. Let me see. I would have put it on. Okay, so a couple weeks ago, that would have put us probably the end of March. Okay, I've got my March dockets here. Hold up, let me see. Okay, so I have March 13th. I have the March 13th docket. Let me see if one of these is an MP4. If it is, I can run it straight. Hold up. I'm looking. Properties. Oh, hold up. Okay. Gettler MP4. Okay, let me see if I can do this, guys. I gotta just find the file path. It is 313. Okay. Give me a second here. We may be getting another bonus court. Tonight's bonus court night. Okay. So now I just got to go back into this one and this one. Oh, come on. I know I did this. I know I did it right. Give me a second here. Do it this way. There it is. Oh, yeah, I was in the wrong one.
All right, looks like we got the jail signed on now. So we will start our morning criminal docket for Thursday, March 13th. We're going to begin, Deputy, with State of Kansas versus Damone Hatch.
All right, Your Honor.
Is your case number 16 CR 97, 20 CR 458, and IPD 25-395. Mr. Hatch appears in custody by Zoom with counsel Ms. Hearn, stayed by Assistant County Attorney Mr. Gayoso. These matters, let me bring in Dwayne Harrington, Mr. Hatch's bondsman as well. We also have in the room, although he has not yet activated his video or audio, we have Mr. Harrington, who is bondsman for Mr. Hatch. These matters were originally set, the 16 and 20 case for bond review. Mr. Hatch having missed court in December, the court issued a bench warrant for his arrest. And I had these cases notices up for hearing today to inquire of Mr. Harrington as a bondsman for Mr. Hatch, his efforts in apprehending him. Mr. Harrington, do you have video that you can turn on for us, please?
I'll be honest, if I do, I don't know how to do it.
Okay. You are the bondsman for Mr. Hatch.
Correct.
Can you tell the court what efforts you made to apprehend him after he missed court a few months ago?
This is the first time I'm hearing that he missed court.
Well, it's your job to keep track of him as a bondsman.
Well, he's checked in, but he's never told me he's missed court. But I talked to him a couple weeks ago, and he said he might have a warrant, but I checked the warrants online and I've never seen one unless I'm checking the wrong deal.
Well, I mean, correct me if I'm wrong, but as a bondsman, you're signing the person out of jail basically as a promise to the court that you will make sure they make their court date. Is that not correct?
Yes, sir, that's correct.
All right, so you should know when he has court and whether or not he makes it.
Well, that's why I asked them to call me after their court dates and give me their next court dates.
Do you not think you have a responsibility yourself to confirm that your clients make their court appearances?
Yes, sir. When was the warrant issued?
December 19th of 2024.
Yeah, I'm sorry, Your Honor. It's my fault that I didn't check up with him, but rest assured I will get him put in jail.
Well, he's with us now. I mean,
he's in court now?
To your benefit and fortune, he got arrested last couple of days on an unrelated matter. So he is in our custody now, but he was not when I noticed his upper hearing and asked you to appear today.
So you don't have to dog the bounty hunter him. They managed to do your job for you.
Okay. Yeah, I talked to him at his house, I don't know, 2-3 weeks ago. And that's when he told me about this court date. And then I got your letter and I'm like, whoa, what's going on here? And that's when he told me that he could have a warrant.
All right. Well, the court is going to revoke Mr. Hatch's bonds in these cases.
Okay. Do you want me to send in our paperwork to revoke them?
Whatever you need to send in.
Okay. And I do apologize, Your Honor. I was not aware that he had missed.
Right.
And that's my fault.
I accept your apology. I would just suggest that if you bond additional people out in our jurisdiction or district, that you do a better job in ensuring they make their court date.
Yes, sir, I will.
All right. You are otherwise free to go, Mr. Harrington. Thank you.
All right. Thank you.
As far as this new case, IAPD 25-395,
I don't want to turn this off.
I'll get you removed, Mr. Harrington. Don't worry about it.
Okay, thank you.
You're welcome. Have a good day.
You too.
All right, the court does find that Mr. Hatch is lawfully in custody, having been arrested on partially a bench warrant for his failure to appear. My review of the probable cause affidavit for the new offenses, quite frankly, the way the affidavit's written, I'm not sure there's probable cause to support interference or driving while suspended, as there's nothing in the narrative regarding Mr. Hatch's driving privileges. Nevertheless, he is lawfully in custody as there were warrants for his arrest. Procedurally, I think we needed to get a trial date scheduled. There might have been pending a motion, a defense motion, if I recall correctly, that perhaps the last court date, it was the court's intention to issue a ruling on that matter. I don't have all of Mr. Hatch's notes with us today, as this wasn't technically formally set for a full-fledged hearing, but rather just a bond review with Mr. Harrington.
That's basically correct, Your Honor. It was a motion by Mr. Gayoso to allow testimony of a deceased witness from the prelim, and then I responded to it.
Correct. I don't have those notes, my notes for those motions with me at the moment. I do know that the defense motion or objection is being denied. The court is going to allow the testimony of the deceased victim witness. I can put the court's formal findings on the record at a later court date.
Thank you, Your Honor.
So are we in position to select a trial date today? I would note that Mr. Hatch is going to remain in custody without bond until trial.
I really hope they don't plan on subpoenaing the witness.
The state's ready to set a trial date of Ms. Hernandez, Your Honor.
Defense is prepared to set a trial date, Your Honor.
All right. How many days do you think you need, Mr. Gayoso?
I believe 2 to 3 days would be sufficient, Your Honor.
And do we know where things stand as far as speedy trial is concerned? I know all delays to date, to my knowledge, have been attributable to Mr. Hatch.
We have 90 days from the date of his arrest, Your Honor, to reset this trial since he failed to appear at the pretrial hearing.
Okay.
Oh, dang. Let me double check that.
These are the time gaps I remove to make it more enjoyable for you guys. This is where the magic happens. This is why I don't run raw footage normally.
My first available, if we want to err on the side of caution and look at 3-day settings, I have April 28, 29, and 30. If this needs set within the next 90 days. I understand council's calendars might be pretty crunched, but you're going to make something work the next 90 days. That'd be my first available 3-day setting.
Your Honor, the conflicts I have on the 29th are in Montgomery County, so I imagine I might be able to work those out. And I have one thing on the 30th that I could probably figure out.
And what were those dates, Your Honor?
April 28, 29, and 30. That's a Monday, Tuesday, Wednesday. If that did not work, I also had available May 19, 20, and 21. That's also Monday, Tuesday, Wednesday.
Got a jury trial set on the 21st of that May date. I've got the April date would work. It's my docket week, but I could find coverage for my docket week.
Okay. And Ms. Hearn, you think you can get your conflicts moved on those?
I do, Your Honor, sorry.
All right. Then we'll set this, and I think it's the 20 case, right? 20 CR 458. Let me see. One moment.
Scheduling is the most boring part of court.
Yes, that's the one that we need to get set. 20 CR 458 will be set for a 3-day jury trial to commence on Monday, April 28th. Proposed instructions would be due April 14. I'm not aware of any other pretrial motions that needed addressed. Again, I'll put the court's formal findings in order regarding the deceased victim witness on the record at a later date, but the court is granting the state's motion in that regard. We'll have the 16 CR 97 case tag along. I think that's just a PV.
Yes, Your Honor.
And then we will set the IPD 25. Again, Mr. Guess, I haven't found probable cause for his arrest on that case, the way the affidavit is written. So I'm not going to set that for a formal first appearance. If your office believes that charges are appropriate and want to file something with an amended affidavit, then you can do that.
Thank you, Your Honor.
Anything further on Mr. Hatch's 3 cases today, counsel?
Nothing from the state.
So, Your Honor, I just want to clarify, you did not set like a pretrial date because we don't have any motions that we expect so far.
Well, we had that already, and the only motion that was pending was the state's. If you anticipate or want to file some pretrial motions beyond that, we can try to get something good in. It'd have to be on my April 10th docket.
At
So
this point, I don't, but if that changes, I can let you and the state know and we can go from there.
I mean, you might have the standard not appearing in restraints and appearing in civilian clothing, which the state rarely objects to, if ever. So I don't think a motion's necessary in that regard. You could probably just submit an order to that effect with the state's approval. But any non-standard kind of pretrial motion, you may consult with Mr. Gayoso, and if there's not an agreement, get it set on that April 10th docket in the afternoon.
Thank you, Your Honor.
Okay, that's all for today. Thank you. State of Kansas versus Gregory Jones. MGI 24 CR 376. Mr. Jones appears in custody by Zoom with counsel, Mr. Jim Villamaria. This is on for review. Last court date was February 13. At that time, there was discussion about a furlough for Mr. Jones to attend treatment when a bed was available. Mr. Villamaria?
That's correct, Your Honor, and that's what we've been working towards. He's been evaluated. Fork County, I spoke with Erica, and Sandy Swart is looking for a bed date. We think we'll have a bed date hopefully today, if not within the next few days. And I'll be applying for a furlough for Mr. Jones. I've met with him. I've discussed that with him. That's something he's interested in doing that. So I believe that it will be coming soon. I would ask the court, Your Honor, if we could set this for review in 30 days, if Mr. Jones is in treatment, I can advise the court of that and his release date. But I believe that we'll have a bed date for Mr. Jones very soon.
Yeah, not to throw a wrench into things too much, I did just receive a message that indicates Mr. Jones has a parole hold
Okay.
and hold out of Franklin County. So that has made the court leery of releasing Mr. Jones on a furlough and question whether I even can with there being a parole hold.
Oh, okay.
So you might explore that a little bit, but we can
I
certainly
will.
review in 30 days and
Okay.
talk about it again. Anything from the state, Mr. Goso?
No, Your Honor.
So next court date, April 10th at 9 o'clock by Zoom.
Okay. Thank you, Judge.
Thank you. State of Kansas versus Dalton Parks, MGI 25 CR2.
Morning, Mr. Gather.
Good morning. Show Mr. Parks appears in custody by Zoom with reciprocal counsel, Mr. Jim Villamaria, stayed by Mr. Gayoso. This is on for review. Last review was February 13. At that time, Mr. Hoffmeister withdrew his attorney of record due to a conflict, and the court appointed Mr. Villamaria. So this is your first appearance with Mr. Parks. Mr. Villamaria, how do you want to proceed?
Your Honor, much like Mr. Jones, we're trying to get him into rehab. I spoke with Erica this morning. They met with him. He still has to have an evaluation done. We hope to get him into an inpatient treatment program. If we could set this matter for review on your April date, I can advise the court as to where we're at that time. But that is the plan we're moving towards, Your Honor.
And much like Mr. Jones, Mr. Parks also has a hold, his being out of Neosho County.
Oh, okay.
So you might explore that. I'm not sure what that case is or what the hold is for, but you might see how that impacts his treatment eligibility. Mr. Gayoso, anything from the state?
No, Your Honor.
All right, next court date, Mr. Parks, is going to be April the 10th at 9 o'clock by Zoom for review.
Thank you.
Thank you. Have a good day.
Thanks, Judge. I will see you this afternoon in Coffeyville.
Sounds good.
Thank you.
I would note for the record on State of Kansas versus Leroy Knoll, MGI 23 CR 313. That was continued by agreed order to my May 8 docket.
I'm still waiting for our girl.
And then Mr. Hoffmeister, we're ready for your cases if you want to make your way to the court laptop. State of Kansas versus Donnie Sumner.
I don't even remember her name now.
With you in one moment, Mr. Sumner, is waiting for your attorney to get logged on.
All right.
Ms. Woolfolk, are you in your office?
Yes, Your Honor.
Mr. Hoffmeister needs to use the court laptop. He says that door's locked. Would you mind letting him in there?
Yes, Your Honor.
Thank you.
We're doing bonus court, Michigan Urbex. Completely unedited, raw docket from the 13th. We're looking for a girl.
I'm here.
All right, very good. We have Mr. Sumner in custody by Zoom with Pacific from counsel, Mr. Hoffmeister, stayed by Mr. Gayoso. This is set for sentencing this morning. Are we ready to proceed as scheduled?
It is, Your Honor.
Defense is.
Okay. Mr. Sumner, did you have a chance to review your pre-sentence investigation report?
I'll talk to my lawyer about it, yes.
All right. And that included your criminal history. Do you recall seeing or reviewing the list of your prior convictions?
Yes.
And was the list of prior convictions for you correct to the best of your knowledge?
Yes.
Any objection then, Mr. Hoffmeister, to a history score of E for your client?
No, Judge, I've reviewed that as well. We anticipated that prior to plea. We believe that's accurate.
State agree?
Yes, Your Honor.
All right. Court will set Mr. Sumner's history score at E. The primary offense for which you're being sentenced today, Mr. Sumner, is possession of methamphetamine with intent to distribute, a level 3 drug felony. With a history score of E, the sentencing range is 62 months aggravated, 59 months standard, and 55 months mitigated. This is a presumptive prison sentence. There's also a special rule that applies, that being special rule number 9, crime committed while on parole. The parole being case numbers MGI 21 CR 306 and 20 CR 529. The effect of that rule as it applies to your case is the sentence imposed in this case, 24 CR 371, must run consecutive to those cases for which you were on parole. My understanding is the agreement per your plea is that you'll serve this sentence. And if that is in fact ordered while incarcerated, you could earn up to 20% good time credit and would be subject to 36 months post-release supervision. You're also required per this drug conviction to register as a drug offender for 15 years. And you did already on December 19 of last year sign and file a notification of procedure and requirements of the Offender Registration Act. So you are aware and been advised of your requirements to register as an offender when you're not in custody. Neither side is seeking departure per the agreement. Is that correct?
That's correct, Your Honor.
Correct, Your Honor.
All right. Mr. Hoffmeister, anything you want to tell the court on behalf of your client? I understand it's pretty straightforward given the nature of the plea, but I'll give you that opportunity if you want.
Judge, it is pretty straightforward. We just ask that you follow the plea agreement, levy the aggravated sentence. Mr. Sumner will serve that. As you see in the PSI, he's also taken responsibility. He had some issues with how his vehicle was searched, but regardless, he has taken responsibility for this, and he's anxious to get his time served and be released and become a productive member of society again.
Let me guess. The officers didn't have a right to search his vehicle. They were probably towing it and doing an inventory search and came across it. All which would be admissible, by the way.
I would like to request the court consider waiving all or a portion of court costs, fines, fees, and attorney fees due to the length of incarceration. And lastly, Mr. Sumner's Toyota pickup was confiscated upon his arrest. I would ask for the court to order that be released to Mr. Sumner's mother, who is Billy Joe Campbell, or his sister, who is Tana Mangan. So that can be released and stored for safekeeping. I don't believe it's of any evidentiary value at this point.
And no, I guess forfeiture actions have been filed with regard to that vehicle.
No.
I'm not certain about that, Your Honor. If there has not been a forfeiture filed, then we don't have any objections to the truck being released to either the mother or the sister. I could follow up on that today.
And Judge, I could tell you that Mr. Sumner's been in custody this whole time. He's indicated to me that he's never received any sort of foreclosure petition. So I don't believe that's the case. But if I'll further confer with Mr. Gayoso and would anticipate being able to file an agreed order releasing that pickup. It's my understanding that's the only item that needs to be released, or are there other items, Mr. Sumner, like your personal belongings?
They're already in booking to be
Okay.
released.
Okay, all right.
Yeah. Just, yeah.
All right, thank you, Mr. Hoffmeister.
That's it for me.
Very good. Mr. Sumner, anything you want the court to consider?
No, Your Honor.
All right. And Mr. Gaddis, on behalf of the state.
Your Honor, we would ask the court to order the 62-month aggravated sentence pursuant to the plea agreement with 36 months of post-release supervision. We would also ask the court to award him 129 days jail credit as of today's date. Order that these cases run consecutive to the MGI 2021 CR 306, as well as the 20 CR 529. The court has already ordered that he register as a drug offender. And as I mentioned, we have no objections to the truck being released with the condition, just to double check to make sure that there is no drug forfeiture forfeiture action on that truck.
All right. Does either side know of any legal reason why the sentence should not be pronounced today?
None known by the state, Your Honor.
Defense knows of none.
All right then, Mr. Sumner, it is the judgment of the court. Your sentence will be as follows. I find the primary crime that controls your base sentence is your sole conviction of possession of methamphetamine with intent to distribute, a level 3 drug felony. It was count 1 of the information. With a criminal history score of E, per your plea agreement, I'm going to sentence you to the aggravated term of 62 months in the Kansas Department of Corrections. That sentence will be imposed. It is presumptive imprisonment. Per special rule number 9, that 62-month sentence will run consecutive to your sentences in MGI 21 CR 306 and 20 CR 529. While incarcerated, you can earn up to 20% good time credit towards that 62-month term, and you will be subject to 36 months post-release supervision. You are also required to register as a drug offender for 15 years, and you are aware of that requirement, again, having filed your notice of duty on December 19, 2024. In light of the period of incarceration, the court is going to waive all costs and fees. For the record, though, Mr. Hoffmeister, what are your attorney's fees?
Judge, we never had any contested hearings in this matter. We were actually able to reach resolution pretty quickly. I'm going to estimate $900.
All right, we'll show attorney's fees $900, but those are being waived along with court costs and fees. We will give you credit for time served toward your 62-month sentence. That is 129 days as of today. There are collateral consequences as a result of your felony conviction. You've lost temporarily the right to vote and the right to possess a firearm. You may in the future have the right to have this conviction expunged or removed from your record. And you have 14 days to appeal the sentence I've just imposed. And if you cannot afford an attorney for that appeal, one will be appointed for you. The court will authorize the release of your vehicle to Billy Joe Campbell and or Tana Mangan, provided there is no active forfeiture action pending. Mr. Sumner, I appreciate you taking responsibility for your actions in this case and understanding that you committed a wrongful act and that you need to do your time and hopefully you come out of prison a better person for it. I will remand you the custody of the Montgomery County Sheriff's Office for transportation to the KDOC to serve this sentence. Anything overlooked to your knowledge, Mr. Hoffmeister?
I don't think so.
Mr. Gayoso?
No, Your Honor.
Any questions about your sentence, Mr. Sumner?
No, Your Honor.
All right, good luck to you, sir.
Donnie, I'll contact you when we have an agreed order releasing your property filed. And I'll also talk to you about the journal entry once I receive it, okay?
All right, could I get a copy of the PSI along? with the
Yes,
journal?
yep, I'll get you another copy of that too. Yeah, it's fine.
All right, thank you, sir.
All right, take care.
Have a good day, folks.
You too.
State of Kansas versus Matthew Cornsilk, NGI 25 CR 81. while they're bringing him out, Mr. Hoffmeister, are you appearing on behalf of Mr. Jones today?
I am as well. He's
All right.
at Leadership Independence for Walker. I am.
Yes. All right. We'll do that one next. I think he's there to use the laptop as well.
Okay.
We'll show Mr. Cornsilk appears in custody by Zoom with the separate from counsel, Mr. Hoffmeister, stayed by Mr. Gayos. So this is on for attorney review. Obviously, the court has appointed Mr. Hoffmeister. Procedurally, this is a felony action, so a preliminary hearing is necessary. But how do you want to proceed today, Mr. Hoffmeister?
Judge, I've been recently appointed, and honestly, I haven't even, my assistants created the file, but I haven't had a chance to review discovery or really much in the file yet. With Mr. Cornsilk being in custody, though, unless he's able to post a bond prior to his next court date, I believe it's probably smart just to schedule a preliminary hearing. If we could potentially address Mr. Cornsilk's bond
Sure.
before we address further scheduling.
We can do that. What I would note, he's just charged with a single count of a level 10 non-person felony, attempted burglary of a vehicle. His bond is $2,500, cash or professional surety with supervision.
Mr. Cornsilk, are you not able to post $250 to a bondsman?
No, sir.
Are you able to post any amount of money for bond?
Maybe $100.
Okay. How long have you been in custody?
I been in here, I think, since February 23rd.
Okay. And where would you be residing if you were to be released?
Back in Coffeyville.
How long have you resided in Coffeyville?
For about 3 years.
Are you currently employed?
No, sir. I was trying to get a job at Acme Foundry.
Judge, this is the first time I've had a conversation with Mr. Cornsilk, so I had to ask a few questions here. I would prefer setting this for preliminary hearing unless the court is willing to reduce bond to an OR with bond supervision, or in the alternative, reduce it to $1,000 cash or surety, which gives Mr. Cornsilk an opportunity to pay $100 to a bondsman to be released. He lives in Coffeyville, it sounds like, for about 3 years. I don't know what his prior criminal history is, so I can't speak on that. But I would ask the court consider those modifications. Provided one of those modifications occurs, I think it would be more appropriate to set this for a further review or settlement conference before we schedule a preliminary hearing. In the alternative, if bond is not modified, then I would ask that we schedule a preliminary hearing date.
Okay. Mr. Yazzo, state's position?
Your Honor, I am reviewing his III, and I do not see, at least initially, any priors. I don't have any objections in the court modifying bond to an OR bond. However, I would request bond supervision. And he may be diversion eligible if, in fact, this III is correct. I don't know if that is something that Mr. Hoffmeister would like to review with his client. My thought is to either set it for review on April 10th, just to see where we're at in the process.
Okay. All right. Assuming that I release Mr. Cornsilk on an OR bond, Mr. Hoffmeister, on the April 10th court date, would you want to do that in the morning by Zoom or the afternoon in person?
Well, Judge, I'm covering for Mr. Jones on that day for Mark Blair in the afternoon. And with Mr. Cornsilk residing in Coffeyville, why don't we just do it in person in Coffeyville that afternoon?
All right. All right, Mr. Cornsilk, what I'm going to do is release you on a $2,500 OR bond with supervision. That means you do not have to post any money to get out of jail. But should you fail to appear for any future court date, you may owe the court $2,500. Does that make sense to you?
Yes, sir.
All right. The bond supervision component of that bond means that as soon as you are released from custody today, you need to immediately report to court services. They have an office here in Independence, which is located next door in the original Montgomery County Courthouse. They also have an office at the courthouse in Coffeyville on 7th and Walnut Street on the 3rd floor. You need to report to one of those two offices today as soon as you are released from custody, and anytime thereafter they direct you to report. Typically that's on a Wednesday in the morning between 8 and noon, but however they want you to report, whenever they want you to report, that's what you have to do. Any questions about that?
No, sir.
All right. Otherwise, your next court date is going to be on Thursday, April the 10th at 1:30 in person in Coffeyville. So when you get out of jail today, check in with court services, check in with them every time they tell you to check in with them, and then go to Coffeyville Courthouse, April 10th, 1:30 in Coffeyville in the large courtroom.
Okay. Thank
Okay?
you.
And that'll be a review hearing.
Okay. You guys have a good day.
Thank you.
Your Honor, if I could
Yes.
request the jail staff write my phone number on the back of that slip, 331-1800. And Mr. Cornsilk, when you are released, have
Yes,
checked
sir.
in on bond supervision and have access to a phone, it's very important you contact me, provide me all your contact information so we can be in touch about resolving your case, okay?
Yes, sir.
Okay,
Thank you.
Have a good day, Mr. Cornsilk.
Okay.
And then State of Kansas versus Michael Walker, who's, I think, there to use a laptop as well. So he'll be
You
appearing
can,
with
you
you.
come sit next to me, Judge.
Okay?
Michael Walker? Michael Walker, come here. Right over here. I'm Mr. Hoffman. Mr. Jones is unavailable today, so I'm in the same front. So come on in, take a seat on that.
My family went over and attended.
Well, let's talk after this because we're not, Judge can hear everything. Take a seat right here. And I'll sit next to you here.
All right, this is MGI 25 CR 68. We'll show that Mr. Walker appears by Zoom with counsel Mr. Hoffmeister, who is appearing on behalf of Mr. Jones today, stated by Mr. Gayoso. And this is another case that was on for attorney review. The court has appointed Mr. Jones. Procedurally, we're ready for selection of a preliminary hearing date. How did Mr. Jones want to proceed today, Mr. Hoffmeister?
Judge, I believe Mr. Jones was appointed last week.
Correct.
He has not had the opportunity to talk to Mr. Walker yet. I believe he prefers scheduling some sort of settlement conference, particularly with Mr. Walker not being in custody, before scheduling a preliminary hearing if necessary. I know that he is unavailable in 4 weeks because I know in the afternoon because I know I'm covering Mark Lair that day. Let me pull up his calendar real quick and see what's going on. Okay. Yeah, that day he has another leadership independence class that takes him out all that day. Is the court willing to set this for a settlement conference in 8 weeks?
On May 8th. That'd be my May docket.
Let me just make sure that.
I presume that's okay with the state.
It is, Your Honor.
Okay.
Mr. Jones has nothing scheduled on that day, so I think that would work best for him.
All right, then we'll set this for a settlement conference on Thursday, May 8th at 1 o'clock in person, and that'll be in Coffeyville, Mr. Walker. So 1 o'clock in person in Coffeyville on Thursday, May 8th.
How many weeks is that from now?
That's 8 weeks, 8 weeks from today.
Okay.
Mr. Hoffmeister's writing that down for you.
Can I ask you a question?
You can. I can't guarantee I give an answer, but you can ask.
Okay. I am trying to do my inpatient drug treatment to where I can wait for a placement for rehab.
Okay.
Am I allowed to do that with me having this big time frame before court?
If you can get yourself into drug treatment, I'm not going to oppose that, Mr. Walker. What I would just ask and I guess order that you do is that if you get into treatment, you notify Mr. Jones or Mr. Hoffmeister where you're going, give them all the paperwork they need to show when you've been admitted, how long your treatment program is for, and if you being in treatment will require you to not be available on May 8th.
Okay.
So I want you to get into treatment if you think you have a drug problem and you want that help. But if you do that and you don't notify anybody and you don't make any efforts to address this May 8 court appearance, you just don't show up, that's going to result in a warrant for your arrest. So just stay in communication with your attorneys and let them know your whereabouts and what you're doing.
Is there any way that you can help with that and putting that in as a court order for me? Because that will also help me a lot easier in me getting into a placement.
I'm not going to issue a court order at this time, Mr. Walker. If that's something that whatever treatment program you're trying to get into requires, to let your attorney know, they can get a hold of the state, and I'm sure an agreed order can be circulated. But I'm not going to, on my own, submit an order today. I'm going to need more information regarding what type of program you're trying to get yourself entered into.
Okay.
Okay?
Yes.
We'll see you May 8th at 1 o'clock in Coffeyville. Just stay in contact with Mr. Jones, okay?
In Coffeyville or here?
It's going to be in Coffeyville.
Okay.
Mr. Walker, I'm handing you my business card. Outside of name and email address, all of that same contact information you can utilize to make contact with Mr. Jones.
Okay.
On the back of the card, I wrote your next court date, which is May 10th, 2025 at 1:30 p.m. in Coffeyville. Okay. So if you have not reached out to Mr. Jones yet or to the office, please call the office and provide all your contact information, because I don't see that we have any contact information written down for you. Okay.
Like, you mean like phone numbers?
Phone numbers, address, call the office and provide all that information to Mr. Jones's assistant.
Okay, I can get those phone numbers for you before I leave. I can give it to you.
Okay, great.
All right. Thank you, Mr. Walker. Thank you, Mr. Hoffmeister.
Thank you.
Thank you, Judge. I think that's everything I have.
All right. And you can just put that on mute. Otherwise, you can just leave the computer
Very
as it
good.
is.
Is it fine to leave the video on?
That's fine.
Okay.
All right. Hello, Mr. Lamson.
Hey, Judge.
We're going to take up State of Kansas versus Ronald Brooks. Case numbers 20 CR 287, 20 CR 364, MGI 21 CR 368, MGI 22 CR 364, and MGI 24 CR 3. We'll show Mr. Lamson appears as attorney of record for Mr. Brooks. Mr. Brooks is in KDOC, state by Mr. Gayoso, and this is on for review for jail credit. We last took this up on February 13th. At that time, the court advised counsel of some letters it had received from Mr. Brooks, questioning whether he was given proper credit for time served, and we passed it today to give counsel time to review that. Did we reach a conclusion on that issue?
Your Honor, if I may, we have reviewed the jail credit. It appears that Mr. Brooks is complaining that on some of his journal entries, he wasn't given jail credit, and that's because, and that is correct, but it is because some of the cases were ran consecutive to each other. So what we are planning on doing is doing a non-pro-tunc showing all the dates that he was in custody, but then marking that he does not get credit for those dates because he was given credit for those dates on another case. I would also, and I've informed that to Mr. Lamson, and he is in agreement with that as well. I would also note we never received any notification from the Department of Corrections regarding discrepancy in jail credit, which they are very diligent in doing. And I'm hoping, I actually debated about the non-pro-tunc because I didn't want to confuse anyone at the Department of Corrections, but I think they'll understand what's going on. So I do believe he was been given all the credit that he deserves and awarded in his respective cases, Your Honor.
All right. Thank you, Mr. Gaz. So you agree with all that, Mr. Lamson?
I do, Your Honor.
All right. And I absolutely agree that KDOC is pretty good at checking the jail credit. We've had a couple of cases recently where we've gotten letters where there's been some discrepancies. So I agree that if they thought there was an issue, they would have brought that to our attention pretty quickly upon Mr. Brooks arriving in their custody. I'm going to show this taken off docket. I'll await the non-pro-tunc order, and hopefully that will clarify things for Mr. Brooks and satisfy his concerns. All right. Christy Westnedge, I think she's in custody. The State of Kansas versus Christy Westnedge, MGI 22 CR 204. Ms. Westnedge appears in custody by Zoom with, but separate from counsel, Mr. Lamson, state by Mr. Gayoso. And this is on for sentencing today. Are we ready to proceed?
State is, Your Honor.
Defense is, Your Honor.
All right. Ms. Westnedge, did you have a chance to review your pre-sentence investigation report?
Yes, sir.
And as part of that, it listed your prior convictions. Do you recall that?
Yes, sir.
And to the best of your knowledge, was the list of prior convictions for you correct?
Yes, sir.
Any objection then, Mr. Lamson, to a history score of E for your client?
No, Your Honor.
State agree?
Yes, Your Honor.
Then we will set Ms. Westnedge's criminal history score at E. The primary offense for which you're being sentenced today is identity theft, a level 8 non-person felony. With a criminal history score of E, the sentencing range is 15 months aggravated, 14 months standard, and 13 months mitigated. This is a presumptive probation case. If probation is granted, it'll be 18 months to community or to court services, excuse me. If you're ordered to serve any sentence imposed while incarcerated, you could earn up to 20% good time credit, and you will be subject to 12 months post-release supervision. Is either side seeking a departure today?
No, Your Honor.
No, Your Honor.
All right, Mr. Lamson, anything you wish to the court on behalf of your client and mitigation of punishment?
Just ask the court, order that standard amount of time of 14 months, that be suspended. She be placed on probation with court services for 18 months. We agree with the other recommendations contained in the PSI.
Okay, thank you, Mr. Lamson. Ms. Westnedge, anything you want to tell the court on your own behalf?
Not that I can think of at this time.
All right,
Thank you.
you're welcome. And I do show a victim impact statement requesting restitution, but I didn't see an amount listed. Mr. Guess, are you aware of whether restitution is being sought?
Give me 1 second, Your Honor. We do not have a request for restitution in any amount, Your Honor.
Okay. And state's position on sentencing.
Your Honor, we would ask the court to impose the standard 14-month sentence to the Kansas Department of Corrections with 12 months of post-release supervision. Suspend that sentence, place the defendant on probation for a period of 18 months to court services, adopt the recommendations of the PSI, and order the standard costs associated in the case.
And how many days credit does Ms. Westnedge have coming to her? Per the PSI, it's 65, 71 days, but there may be additional time beyond that.
And Your Honor, I'm not certain how long is her current incarceration, but we will make sure that that gets added to the journal entry.
All right. Does either side know of any legal reason why the sentence should not be pronounced today?
None by the state.
None by defense.
All right, Ms. Westnedge.
Yes, sir.
It is the judgment of the court. Your sentence will be as follows. I do find the primary crime that controls your base sentence is identity theft, a level 8 non-person felony. With a criminal history score of E, I'm going to sentence you to the aggravated term of 15 months in the Kansas Department of Corrections. I will, however, suspend that sentence, Ms. Westnedge, and place you on probation with, and I'm going to place you on community corrections probation for 18 months. I'm imposing the aggravated term and placing you on community corrections probation because even though this is a level 8 non-person felony, which is relatively minor compared to other offenses, you have a laundry list of convictions for these types of crimes, Ms. Westnedge, a number of convictions for stealing, for forgery, for theft, larceny, a multitude, fraud, abuse of credit cards. So this is not an isolated incident. This is a pattern of you for these types of crimes. And so I think the aggravated term and community corrections is appropriate. And if you haven't already spent 71 plus days in jail, I probably would have ordered you to spend some time in jail as a condition of probation, but you're already doing that essentially.
Yes, sir. Thank you.
In the event you were to violate your probation and you had to serve this 15-month sentence while incarcerated, you could earn up to 20% good time credit and would be subject to 12 months post-release supervision. I'm going to order you pay court costs of $193, a probation fee of $120, a fingerprinting fee of $45. There will be a $200 DNA collection fee, as this appears to be your first and hopefully last felony conviction out of the state of Kansas. What are your attorney's fees, Mr. Lamson?
They would be approximately $1,200, Your Honor.
All right. Ms. Westnedge, there are some fees associated with Mr. Lamson's representation. They include a $100 application fee, and it looks like up to $849 is the max the court can impose for a non-tried level 8 non-person felony. Do you have the means in which to reimburse the state those expenses?
Not at this time, but I should within, I would say 30 days.
But what? I didn't catch the last part of that.
I should be able to pay something within 30 days.
Within 30 days.
Yes, sir.
When you're not in jail, how do you support yourself when you're not stealing and forging?
Well, I just do odd jobs, but I have my CNA and I'm waiting on my birth certificate. And I just did the thing for my social security card, so I can shouldn't have a problem getting a CNA job. I've never have before. Home health care.
You're not concerned that in light of this felony conviction and your other convictions for theft and stealing, that might not affect your CNA license? I'm concerned that it might.
Well, if it does, I have I can do I've done housekeeping, I've done other jobs, so I shouldn't have a problem finding a job, I wouldn't think.
All right. Well, I certainly admire your optimism. I'm not as quite optimistic that you're going to have success in getting employment, given the nature of your convictions, but I do wish you luck in that regard. I'm going to order you pay the application fee of $100. I'm going to order you pay $250 of the attorney's fees, a portion thereof. You are capable of working, as you've indicated, but I think imposing the maximum amount might be a burden or hardship upon you.
Okay.
So I'll assess the application fee of $100 and $250 attorney's fees. There's no restitution being sought or ordered. We will give you credit for time served. Your attorney and Mr. Gayoso will speak to determine what that precise number is. It's at least 71 days, and it's going to be more than that as well. And that will be reflected in the journal entry.
Yes, sir.
The court is adopting all recommendations as set forth in the PSI as conditions of your probation. There are collateral consequences as a result of your conviction. You've lost temporarily the right to vote and the right to possess a firearm. You may in the future have the right to have this conviction expunged or removed from your record. And you have 14 days to appeal the sentence I've just imposed. And if you cannot afford an attorney for that appeal, one will be appointed for you. Any questions regarding your sentence, Ms. Westnedge?
No, sir.
Anything overlooked to your knowledge, Mr. Lamson?
No, Your Honor.
Mr. Gayoso?
No, Your Honor.
All right. Good luck to you, Ms. Westnedge.
Thank you very much. Have a
You
great day.
you as well. When you get out of jail today, you do need to immediately check in with court services or community corrections. They're in the basement of this building. So
Okay.
as soon as you get out of jail, go to the basement of this building and check in with community corrections. They'll be waiting for you.
Okay. Thank you so much.
Thank you. State of Kansas versus Ernest Washington III. These are case numbers MGI 22 CR 411, 23 CR 300,041, 23 CR 300,049, and 23 CR 74. Mr. Washington appears in custody by Zoom with, but separate from counsel, Mr. Lamson, stated by Mr. Gayoso. And this is on for competency review. We've been waiting on a bed for Mr. Washington at Larned State Hospital. On February 13th, he was number 31 on the list. Where is he today, Mr. Lamson?
He's number 25, Your Honor.
No, not as much progress as I thought there would be, but it is progress. Mr. Washington, we've been through this a number of times. As you're aware, there's nothing we can do until your competency is restored. And so all we can do is review this on my next docket to see where you are on the list. unless council has another suggestion.
I
No,
think
Your
that's-
Honor.
That's appropriate, Your Honor.
All right, next court date, Mr. Washington, is April the 10th at 9 o'clock by Zoom for review.
Thank you.
Thank you, sir.
Thank you, sir. You have a good day. You too. God bless.
I'm gonna bring in Stacy Kirk from the waiting room.
Is this our girl? I don't know. I think she'd be in custody.
See. Hello?
We can hear you, Miss Kirk. You need to turn your video on, please.
Turn my video on. Okay, here I am.
There you are. State of Kansas
Here I
versus
am.
Stacy Kirk, 20 CR 452. Miss Kirk appears by Zoom with, but separate from counsel, Mr. Lamson, state by Mr. Gayoso. And this is on for admission denial on a motion to revoke probation. How would you like to proceed, Mr. Lamson?
Your Honor, we'll go ahead and enter denial today. And we would ask that the matter be continued to April 10th at 1 o'clock in person in Coffeyville for a settlement conference or an evidentiary hearing, whichever the state prefers.
Mr. Gayoso?
We would just ask that he be set for an evidentiary hearing at 1:30, Your Honor.
All right. So we'll show a denial entered, Ms. Kirk. We're going to set your case for an evidentiary hearing on my Thursday, April 10th docket at 1:30 in person in Coffeyville.
April 10th at 1:30.
In Coffeyville, you got it.
Coffeyville, got it.
We will
Your
see
Honor?
you there. Yes, go ahead, Mr. Lamson.
I just wanted to make sure Ms. Kirk had my contact information.
Yes, I do, sir.
Okay,
I
give
mean,
me
I
a call. Give me a call so
times.
we can set up a time to visit, okay?
Okay, yeah, I contacted you a couple times, so yes, I have it, sir.
Okay, thank you.
I'll sure contact you before then. You
We
have a
will
good day.
see you, we'll see you April 10th, Ms. Kirk. You have a good one.
April 10th, you too. Have a great day. All right.
Thank you. All right, Mr. Lamson, the remaining two clients I show for you are Stephen Napper and Pia Scott. I don't think either one is here to use a laptop, and neither one appears in my Zoom waiting room. Do you have any information on either of those individuals?
I thought Pia Scott was in custody, Your Honor.
She is not in custody, I don't believe. We're double checking.
I did check with Larned State Hospital, and Pia Scott is number 26 on the list for a bed. I think the females open up a little faster than the males.
Okay. It looks like Miss Scott bonded out.
Okay.
On February 8th. And it has today's court date and time. Ms. Shoup, do you have information on Miss Scott?
Yes, Your Honor, she has been reporting weekly with us.
I've not had contact, Your Honor.
And I appreciate that she's reporting to you, but this is not her first time failing to appear in court. I also am aware that she has some mental health issues for which she is seeking treatment, which probably doesn't help with scheduling and recalling court dates. She reported yesterday, Ms. Shoup?
She did, Your Honor.
Right. And was today's court date discussed at all?
Yes, sir.
So no
Your Honor,
reason.
I don't know that she's capable of logging on to Zoom without some type of assistance. Or I would worry about that anyway.
Well, I think she's used our laptop before, so she's aware that's an option. I'm willing to pass this to my April 10th docket in the afternoon. Give her one benefit of the doubt. Mr. Gasso, what's your state's position?
Judge, that's exactly what I was thinking as well. I would ask that it be set for the 1:30 in the afternoon docket and just have, court services inform her of that date when she next appears for reporting.
All right, we'll pass this to April 10th at 1:30 in person in Coffeyville. Ms. Shoup, if she reports to your office next Wednesday, is that when she's supposed to report next?
Yes, Your Honor.
If you would be so kind as to notify her of that court date, and if you wouldn't mind filing something indicating that you advised her of her court dates.
Yes, Your Honor.
Okay, thank you. And then State of Kansas versus Stephen Napper, MGI 24CR8. Mr. Napper does not appear. He was here on February 13, and the matter was passed to today. You've not had any contact with Mr. Napper?
I have not, Your Honor. I'm just checking my file to make sure, but I don't believe that I have. I have not.
How come? Why not?
I had a telephone conference with him back on February 11th, but no contact since then.
That's my daughter's birthday.
Okay. This appears to be Dwayne Harrington Bond, so I may have to have him come back. Court's going to issue a bench warrant for Mr. Napper. That's all I show for you, Mr. Lamson, until this afternoon.
That's all I have, Your Honor.
All right, thank you.
Thank you. I'll see you this afternoon.
State of Kansas versus Trey Thompson. This is MGI 25CR96. Mr. Thompson appears in custody by Zoom without counsel, stayed by Mr. Gayoso. This is on for a formal first appearance. Mr. Thompson, you are charged in a 3-count information with the following. Count 1 is aggravated residential burglary. It is alleged that on or about March 5th, 2025 in Montgomery County, Kansas, that you unlawfully, feloniously, and without authority entered into or remained within a dwelling in which there is a human being with the intent to commit a felony, theft, or sexually motivated offense. That's a level 4 person felony, carries a possible penalty of 38 to 172 months in prison, a fine up to $300,000, and 36 months post-release supervision.
I honestly, genuinely could not even imagine being in my home and having this gentleman break in, walk in, whatever, with the intent to commit a motivated crime of that sort. I'd be grabbing my pew pew real quick, a flamethrower, Screw the pew pew. I'm going straight for the flamethrower.
And count 2, you are charged with criminal damage to property. Is alleged on or about March 5th, 2025 in Montgomery County, Kansas, that you unlawfully and knowingly, by means other than fire or explosive, damaged, destroyed, defaced, or substantially impaired the use of property, to wit, a door and or door frame, to the extent of less than $1,000 in which another person had interest, to wit, Brandon Donna, and without the consent of such person. This is a Class B non-person misdemeanor, carries a possible penalty of up to 6 months in the county jail and or fine up to $1,000. In count 3, you are charged with theft. It is alleged on or about March 5th, 2025 in Montgomery County, Kansas, that you unlawfully obtained or exerted unauthorized control over property or services, to wit, a can of strawberry margarita Cayman Jack, with the intent to permanently deprive the owner, Tiffany Moore, of the possession, use, or benefit of the property or services. And the value is less than $1,500. That's a Class A non-person misdemeanor, carries a possible penalty of up to 1 year in the county jail and or a fine up to $2,500. Do you understand what you're charged with in this case, Mr. Thompson?
Yes, sir.
All right. You appear today without an attorney. Did you intend on hiring your own, or did you want the court to consider appointing you one?
Maybe to appoint me one.
All right. Have you had an opportunity to fill out an application and an affidavit for court-appointed attorney?
No, I haven't, not yet, sir.
All right. The deputy's going to hand you an application and an affidavit. If you'd get that filled out and return to a deputy or jailer there today, upon receipt, I will review it. And in all likelihood, I will appoint an attorney to represent you.
It won't take him long to fill it out, Your Honor. It doesn't take that long to write a 0 right on it.
Okay.
It looks like that you are currently on probation in case number 23 CR 184. That is a case assigned to me. As a result, this new case will be reassigned to me. It was originally assigned to Judge Gossard, but we're going to show that this case, 25 CR 96, is reassigned to me.
Mhm.
Your next court date, April 10th, work for the state for review.
Yes, Your Honor.
Next court date will be April the 10th at 9 o'clock by Zoom for attorney review. Any questions, Mr. Thompson?
No, and I have to stay in here till April 10th.
Unless you post bond, which is currently $75,000, cash or professional surety of electronic monitoring.
You said, or professional assurance of electronic monitoring.
If you go through a bondsman, you pay, in all likelihood, $7,500.
You said, okay, and then, or I could do electronic bond or
Electronic monitoring. Electronic monitoring is a condition of your bond, so it's not one or the other. It's in addition to posting the cash component or going through a bondsman, you also have to get yourself equipped electronic monitoring.
Okay.
All right. Anything from the state, Mr. Gayoso?
No, Your Honor.
We will see you April the 10th. Thank you.
If you want to go back in there, because the room needs it for caretaking.
Austin Ott, I'm not quite sure to pronounce that last name.
Your Honor, I will inform you that we have declined charges at this time. He does have a hold out of Jasper County, Missouri, and I believe he has already waived extradition to take it back.
All right. You are Austin, is it Out?
Yes, sir.
All right. Mr. Out, you are appearing in custody by Zoom. This was set for a formal first appearance. However, the state at this time is declining to file charges against you. That does not mean they may not do so in the future, but for now, they are not pursuing a criminal case against you. That means that you are no longer being held in our custody on this case, but as I understand it, you do have a hold out of Jasper County and you have waived extradition, so you'll be going there next. But you have no further obligation to the court as it pertains to this case at this time.
Okay, can you tell me what my hold is in Jasper County, sir?
It's for kidnapping in the second degree.
Okay.
Alrighty, what you might do, Mr. Out, is leave a good address for you with the jail there. The purpose of that is in the future, should the Montgomery County Attorney, should they decide to file charges against you, if they have a good mailing address for you, they can summon you to appear in court on your own as opposed to having an arrest warrant issued for you.
Okay.
If they don't have a good address in which to mail you a summons to appear, the only alternative is to have you arrested.
Yes, sir.
Okay, so leave your address to somebody, but otherwise you'll probably be shipped off to Jasper County sometime soon.
All right, thank you.
Thank you.
He was so casual about it. If I got told I was being charged with kidnapping, I would have a panic face. This guy just had that grump face the whole time. And he was so accepting of the charges. Oh, okay, that, yeah. What? Wow. Seasoned criminal.
And Ms. Wolfolk, we'll take up Mr. Holman here in a moment.
Yes, Your Honor.
I'm going to bring in Darian Elias. And then we'll take up Thomas Holman, who's using a report laptop. Mr. Elias, if you will please unmute yourself and activate your video for me.
There we go. Sorry about that.
You're good. State of Kansas versus Darian Elias, MGI 25 CR 58. Mr. Elias appears by Zoom without counsel, stated by Mr. Deoso. And this is set for attorney review. Mr. Elias, I don't show that we have an application or affidavit from you for court-appointed counsel. Did you plan on trying to hire your own attorney?
I was trying to acquire the funds by doing so, but I have not been able to. And since I've not had my job, I've had to use a text now app. I haven't even had my regular phone number. So I have not been able to do so.
Okay. Well, if you want the court to appoint you an attorney, you'll need to make your way to the Judicial Center.
Okay.
Are you in Independence or Coffeyville right now?
I live in Coffeyville, Kansas at the
Coffeyville,
moment.
okay. Then you can go to the Coffeyville Courthouse.
Okay.
Go to the third floor where the clerk's office is, and they can get you an application and an affidavit or court-appointed counsel. Fill that paperwork out. We'll review it, and if you qualify financially, we can appoint an attorney for you.
Okay.
Before I give you your next court date, I do need to review with you. There was filed an affidavit from Court Services. As you may recall, a condition of your bond was supervision, and you have failed to report for intake, and you've also no called or no showed. It looks like on February 4, February 26, March 5th, and March 12. Is there a reason why you have not been compliant with bond supervision?
No, I called them in Coffeyville, Kansas, I believe, at the beginning, and I don't remember I forgot. I guess I was supposed to go talk to them. And was it supposed to be in person or what? Because I don't remember having to talk to them after that. I talked to Ron and everything. That's my bondsman, but I haven't talked to anybody supervision wise.
Okay. Well, as a reminder, you're supposed to check in with Court Services.
Okay.
Report to them. Typically, it's once a week on Wednesday between the hours of 8 and noon. Whether that's by phone or in person is up to them.
Okay.
Now, what your bondsman wants you to do, that's between you and your bondsman, but this is totally separate from that. Ms. Shoup, what information has been relayed to Mr. Elias from your
Your
office?
Honor, he did call in one time. We advised him to come directly in to complete intake and discuss further reporting instructions. He's not done so.
Right. Do you recall that, Mr. Elias?
I do. I remember talking to her. I just didn't remember what the next following steps were, so I do apologize on that. I just was kind of confused on the whole situation.
Your Honor, I would ask the court to order that he appear to Court Services at a specific date and time to conduct the bond reporting intake.
Yeah. Mr. Elias, you need to go in today.
Say that one more time. I'm sorry.
I can't report to Court Services in Coffeyville today.
Okay.
So the courthouse, third floor, 7th and Walnut Street. before 4 o'clock today, you need to go there, fill out the intake sheet, and then follow their instructions thereafter. Again, typically it's reporting once a week on Wednesdays between 8 and noon, but however and whenever they want you to report, that's what you need to do.
Okay. I do apologize again on that. I am very confused on that proceeding, so I do apologize.
Well, hopefully that confusion has been alleviated. And while you're there at the courthouse, you can go to the clerk's window and get that application affidavit for a court-appointed attorney.
And you said I can also, in Coffeyville, I can do that?
Correct. That's where you'll do it.
Okay.
Your next court date after today is going to be April the 10th. And that'll be at 9 o'clock by Zoom or whatever time we call your case, but April 10th at 9 o'clock by Zoom.
Okay.
All righty. Any questions, Mr. Elias?
Not at the moment. No, I do not.
All right. Anything further from the state, Mr. Gayoso?
No, Your Honor. Thank you.
We will see you then. Make your way to the courthouse today, Mr. Elias. Thank you.
All right. Thank you.
State of Kansas versus Thomas Holman, MGI 22 CR 545. Mr. Holman appears by Zoom from the court laptop. State by Mr. Gayoso, and this is on for review on a motion to revoke diversion, I believe. Mr. Holman, you were issued a summons to appear, and you have complied with that, appearing today by Zoom. Do you intend on hiring an attorney to represent you in this matter? Mr. Holman, do you want the court to consider appointing an attorney?
I can't afford to hire one right now, so if I need an attorney, I guess you guys will have to appoint one.
If you qualify financially, I've been more than happy to do that. So Ms. Woolfolk, who's in that room with you, she's going to give you an application and an affidavit. You need to fill that paperwork out today, leave it at the clerk's window out in the lobby before you leave. And if you qualify financially, I'll be more than happy to appoint an attorney to represent you. Because you did appear on a summons, we do need to address the issue of bond. Mr. Gayoso, are you okay with the $2,500 OR bond?
It is, Your Honor.
All right. I'm going to allow you to remain out of custody, Mr. Holman, on a $2,500 OR bond. That means you don't have to post any money, but should you fail to appear for a future court date, you may owe the court $2,500. I am going to have you processed in the jail as well. So you will need to, when you leave this current floor that you're on, go down to the sheriff's department and be processed in and out. We're not going to take you into custody. You're not going to spend any time in jail. They just need to process you in and out. And then you'll be released on this OR bond with instructions to reappear on my April 10th docket at 9 o'clock by Zoom. So that'll be your next court date, April 10th at 9 o'clock by Zoom. You're welcome to come back here and use our laptop if you need to. If you're able to get onto the Zoom on your own from your home or place of employment, you can do that as well. So long as you're able to get on and I can hear you and see you, you'll be good to go. Any questions about any of that, Mr. Holman?
No, I was gonna say if I needed to pay on my diversion today, I could pay $120. I got that. I might be able to pay a little bit more today on my diversion and be like, well, if I pay the diversion off, I should be good. Is what I understood.
Well, the agreement is between you and the state. They believe that you're non-compliant with the terms of the agreement. Whether you choose to make a payment today or not, that's up to you. I can't speak to whether that'll satisfy the state's concerns with your compliance or not. But if you owe money on this diversion, it'd probably be in your best interest to pay what you can when you can. But I can't tell you how that would affect the outcome of this case.
Okay.
All right. Anything from the state, Mr. Gayoso?
No, Your Honor. I do believe it would be to his benefit to try to get this paid off as quickly as possible.
All right. So, Mr. Holman, if you can make a payment, I suggest you do it. Get that application filled out, leave it with the clerk's window in the lobby, and then make your way downstairs to the sheriff's department so they can process you in and out. And we'll see you on April the 10th at 9 o'clock by Zoom.
Okay.
Thank you very much.
All right.
Ms. Woolfolk, is there anybody else appearing for the laptop today?
No one, but I'll double check in the hall, Your Honor.
Okay, thank you.
Now the awkward silence. And I don't know how long it lasts for. What is that pen that's just randomly waving in the bottom corner? Whoa, it's getting animated. Come on, give me the pen back. That was funny.
I showed 2 individuals remaining for the morning docket. That includes Jasmine Herring, MGI 25 CR 29. And that is on for a formal first appearance.
Come on, and our girl.
It looked like that was a summons that was issued, but there's no service.
I'm checking. That's what I was checking, actually, Your Honor. And I couldn't tell whether we had service or not. We could try to do an alias one more time.
The return says was not found, vacant house, evicted occupants last year.
Okay, we will probably go ahead and request an arrest warrant then, Your Honor.
And I will approve that when it makes its way to my queue.
Okay, thank you.
We'll take Miss Herring off docket for now. And then we have William Pearson, MGI 25 CR 92. And he's appearing from court services. Okay, excellent. Mr. Pearson appears by Zoom from Cottville Court Services, stated by Mr. Gayoso. And this is on for formal first appearance. Mr. Pearson, can you hear me okay?
Yes, sir.
Okay. You are charged in a 4-count information with the following. For sake of brevity, each of these are alleged to have occurred on or about March 1st, 2025 in Montgomery County, Kansas. Count 1 is aggravated assault. It is alleged that you unlawfully, feloniously, and knowingly placed another person, Jory Lillian Rebecca Pearson, in reasonable apprehension of immediate bodily harm with a deadly weapon, to wit, a silver handgun. That's a level 7 person felony, carries a possible penalty of 11 to 34 months in prison, a fine up to $100,000, and 12 months post-release supervision. Count 2 is aggravated domestic battery. It is alleged that you unlawfully and knowingly impeded the normal breathing or circulation of the blood by applying pressure on the throat, neck, chest, or by blocking the nose or mouth of a person with whom you are involved or have been involved in a dating relationship or a family or household member, to wit, Jory Lillian Rebecca Pearson, and done in a rude, insulting, or angry manner. That is also a level 7 person felony, carrying the same possible penalty as count 1. Count 3, you are charged with criminal threat. It is alleged that you unlawfully and feloniously communicated a threat to commit violence, communicated with the intent to place another in fear, to wit, Jory Lillian Rebecca Pearson. That's a level 9 person felony, and that carries a possible penalty of 5 to 17 months in prison, a fine up to $100,000, and 12 months post-release supervision. And count 4 is theft of property or services. Firearm less than $25,000. It is alleged that you unlawfully, feloniously, and intentionally obtained or exerted unauthorized control over a firearm of a value less than $25,000 with the intent to permanently deprive the owner, Thomas Perry Angleton, of the possession or benefit of the firearm.
Was it the same silver pew pew mentioned earlier?
That's a level 9 non-person felony, and that carries the same possible penalty as count 3. Do you understand what you're charged with in this case, Mr. Pearson?
I understand, Your Honor.
Okay. And you are appearing today without an attorney. Did you intend on hiring your own, or did you want the court to consider appointing you one?
Hiring my own, sir.
Okay. Have you made an effort to do that yet?
Yes, I've given him a call. We're going to try to take care of it in the next few days.
Okay.
I'm just kind of waiting on the money.
I understand that. It's not cheap. I know that.
Yes.
Okay. I show that your case is assigned to Judge Gossard. So your next court date is going to be on Thursday, March 27th. So 2 weeks from today at 9 o'clock in person. So you'll be in Independence at the courthouse here at the Judicial Center in Independence, 300 East Main,
Yes, sir.
second floor. That'll be at 9 a.m. And that will be for attorney review. If you have not yet hired an attorney, you'll want to let Judge Gossard know the status of your efforts at that time.
Okay, sir.
If at any point you find that you are financially unable to hire an attorney, you are able to get an application and an affidavit from our clerk's office. You can fill that out. We'll review your financial information, and if you qualify financially, we can appoint you an attorney. But if you want to hire your own, you're certainly welcome to do that if you have the means to do it. Any questions, comments, concerns?
No, sir.
All right, anything from the state?
No, Your Honor.
Then we'll see you in 2 weeks, March 27 at 9 o'clock. Thank you, Mr. Pearson.
Thank you, sir. May I go?
And we
Okay,
do
thanks.
now have Mr. Napper has joined us late. I'm gonna bring him in, his attorney. Mr. Lamson, are you still around? I see you're still in the room.
Oh, there is nothing like loading up your Zoom, turning on your camera, and having a dead end sign, a city street sign in the background. That the only way to acquire that sign, because I know you didn't purchase it on Amazon or anything like that, you had to have stolen that from a city street, which is a $500 fine just for tampering with it, and then the theft charge, and then so much more. You're a genius, my friend.
All right, Mr. Napper, can you unmute yourself, please?
Hello.
All right. Where were you when we called your case?
I am so sorry. I couldn't find a computer or a way to get to Zoom. I finally got my computer.
All right. Well, better late than never, I suppose. I did issue a bench warrant for your arrest, but since you have joined us, I will not execute that. So you're fortunate that you got signed on when you did, because we were just about to finish the docket. So you were a couple minutes away from having a warrant for your arrest. Your attorney has already come and gone. So what I'm going to do today is just give you another court date to appear. I would suggest that you be logged on at the time you're supposed to. And if you can't get a computer that works, you need to make your way to the courthouse and use our laptop.
And that's in Independence, right?
Correct. Would an in-person appearance be better for you in Coffeyville?
No, I got the whole computer situation together now. I'm sorry about that. You said have you already gave a date for the next court?
I have not yet. Does April 10 work, Mr. Gayoso?
It does, Your Honor.
All right. So April the 10th at 9 o'clock, Mr. Excuse me.
Sorry, grabbing a pencil.
All right. You got that, Mr. Napper? April 10th at 9 o'clock by Zoom?
Yes, sir. Thank you.
And again, if you have any difficulty getting logged on, you'll need to make your way to the courthouse, use our computer. At a minimum, you need to call the clerk's office and let us know you're having difficulty. That way we don't think you just didn't show up.
Yes, I appreciate you.
He wasn't having difficulty. He was asleep From the moment he logged on, he was rubbing his eyes and trying to wake up. I'm surprised he didn't give himself a good slap.
Communication is key. So we'll see you April 10th at 9 o'clock.
All right, see you then.
Thank you. All right, Mr. Gale, so I do need to take up care and treatment. It is 10:31 now. They shouldn't take too long to just reviews, I think. And then we'll take up the first appearances, if that's okay.
Yes, I'm gonna head to the restroom and I'll be back.
Okay, thank you. So we're going to stop this live stream for a little bit while I take up some confidential cases, and then I'll reconvene.
Oh, so we didn't get our girl, but we did get a whole lot of fun. I'm going to keep looking. I'm going to see if I can find it. Maybe I have it somewhere. Because he did say he was coming back on, so maybe it's a later stream, and I don't know. I'll have to look. I will have to look. I'll keep looking. Yes. Yeah, that's a good possibility, my love. Wow, guys, a 3-hour stream. Haven't done that since Gilligan. All right. I am going to try to get a little bit of sleep. Just a little bit. Because in 4 hours, roughly, I need to start docket harvesting again. And trying to put together cases for tonight. At least we know we're getting some more Judge Gatler, because it's today. It is stupid o'clock. It is definitely stupid o'clock. It's been stupid o'clock for a hot minute. I love you. Man, I had so much fun tonight. You guys are truly the best. Absolutely the best. And I cannot thank you enough for coming out and hanging out with me. I truly did. I had a blast. I had just the most glorious time. And you guys are amazing. You always brighten my day. You make me feel better. And I love you for it. Thank you so much. Thank you for being the amazing, wonderful, glorious people that you are. I couldn't ask for better family. Be safe, be well, sleep sweet, and much love.